Rip. Here. Culp. Here. Talkin. Here. Vorpagel. Here. Sinicki.
Here.
Samaripa. Call. Here. Onstead. Rostov.
Okay, this morning the committee will be holding an executive session on Assembly Bill 633, 641, and AB 730. After that, we will have a public hearing on Assembly Bill 721, 724, 779, and AB 800. If you are here to speak on any one of those bills, I'd appreciate it if you see our main man Scott at the door, fill out one of the white slips so we get your testimony entered into the queue, and we'll call on you when we get to you. With that, I'm going to move into executive session. And we will start with Assembly Bill 633, and I will have Ledge Council describe the bill.
Sure. Assembly Bill 633 authorizes local registrars to issue certified copies of certain types of vital records that, if those records are available for statewide issuance through the state registrar's electronic database. Under current law, only the registrar that was responsible for filing a register to issue a certified copy, or can issue a certificate.
Okay, I'm entertaining a motion for passage of Assembly Bill 633. There are no amendments. Moved by Representative Branchin, second by Talkin. Any discussion on AB 633? Seeing none, the clerk will call the roll.
Representative Swearingen.
Aye.
Craig. Jagler.
Aye.
Branchin.
Aye.
Rip.
Aye.
Culp. Talkin. Vorpagel.
Aye.
Sinicki.
Aye.
Samaripa. Call.
Aye.
Onstead. Rostov. Motion carries.
Okay. Next, we'll move to AB 641, eliminating the Joint Survey Committee on Tax Exemptions. Also, there are no amendments to this bill, and I will have Ledge Council describe AB 641.
There isn't a lot more to say about this bill than the title of it. The bill eliminates the Joint Survey Committee on Tax Exemptions, which is a joint committee, a statutory committee of the legislature that is tasked with reviewing bills that create new tax exemptions in the state.
Okay, is there a motion to recommend passage of AB 641 by Vorpagel, second by Rip? Any discussion? Well, coming from a member of this committee, may today be the last time they meet. Right after they pass one of my bills. The clerk will call the roll.
Representative Swearingen.
Aye.
Jagler.
Aye.
Branchin.
Aye.
Rip.
Aye.
Culp.
Aye.
Talkin.
Aye.
Vorpagel.
Aye.
Sinicki.
Aye.
Samaripa. Call.
Aye.
Onstead. Rostov.
Aye.
Motion carries.
We will move now to Assembly Bill 730 regarding local regulations of certain containers. There is one amendment for this bill. There's two amendments to this bill. I will have Ledge Council first describe amendment number 1.
Sure. Assembly Bill 730 prohibits local units of government from taking specified actions to regulate auxiliary containers. That's a defined term under the bill that includes several types of packaging. Assembly Amendment 1 to the bill, I believe, was introduced by the bill's author. The amendment under the bill, auxiliary container includes specified types of bags, cups, bottles, and other packaging. The amendment specifies that the definition also includes cans.
So is there a motion to recommend adoption of Assembly Amendment 1? Motion by Vorpagel, second by Jagler. Any discussion on Assembly Amendment 1? Seeing none, the clerk will call the roll on the amendment.
Representative Swearingen.
Aye.
Jagler.
Aye.
Branchin.
Aye.
Rip.
Aye.
Culp.
Aye.
Talkin.
Aye.
Vorpagel.
Aye.
Sinicki.
Aye.
Call. Aye. Rostov.
No.
Okay, we will move to Assembly Amendment 2 to Assembly Bill 730, and I will have Ledge Council describe this amendment.
Sure. Among other provisions, the bill prohibits local governments from imposing fees, charges, or surcharges on auxiliary containers as defined under the bill. This amendment was introduced by Representative Sinicki. The amendment clarifies that the prohibition on regulation under the bill does not apply to special charges imposed for services provided by a political subdivision.
Okay, is there a motion to recommend adoption of amendment number 2?
So moved.
By Sinicki, is there a second? By Brostoff? Any discussion on amendment number 2?
Can I ask,
Representative Vorpagel?
can I ask the Ledge Council, so currently, if the bill prohibits a municipality from imposing a fee charge on containers, but how does this, it doesn't really address the charges that are, does this change? This amendment, would it change anything as part of the bill?
I think it's likely that a court would find that the prohibition in the bill doesn't prohibit a local unit of government from charging for, say, the service of recycling pickup. But, and the author can speak to the intent, but the intent might be to just to clarify that point. I think it's not, I mean, there could be, someone could raise an argument that a fee on an auxiliary container could include a fee for recycling the container. But, you know, like I said, I think that's an unlikely interpretation, but it's not impossible.
Representative Sinicki?
Thank you, Mr. Chair. Excuse me. I've had a really bad cold the last 2 weeks, so. Currently, many cities do charge for curbside pickup on recycling. And as you said, it's just, I wanted to clarify that they will still be able to charge for that service. Given the fact that we've really cut recycling grants, if some cities cannot, you know, if it's not clarified that they can still continue the fees, it's going to put a real hole in their budgets if they have to cut the fees for that service at this point.
Okay. Representative Call?
Yeah, thank you. It's just to clarify, just so there wouldn't be any more challenging when folks like WMC were here to testify in the public hearing,
Yeah.
they agreed that was not their intent. So this is simply to allow municipalities to still charge those fees without having to go through a potential court battle. Because I don't think that's what the bill's authors intended either.
Okay. So, and I'll ask this again too, is this clarification needed?
I guess, without sort of rendering a yes or no on whether it's needed, I think I'll just say that I think it's probably unlikely that a court would say that this bill, the effect of this bill is to prohibit a local unit of government from charging a fee for recycling pickup. And certainly there is another provision of the statutes that specifically allows the charging for such services. I think certainly the language clarifies that there wouldn't be a conflict between the bill and that existing provision.
Okay. Any other discussion? Seeing none, the clerk will call the roll.
Representative Swearengin.
No.
Jagler. No. Branchen. No. Rip.
No.
Culp. Tauken.
No.
Vorpagel. No. Sinicki.
Aye.
Same Ripa.
Aye.
Call. Aye. Onstead. Brostoff.
Okay. Is there a motion to recommend passage of Assembly Bill 730 as amended? By Branchen, second by Tauken. Any further discussion on Assembly Bill 730? Seeing none, the clerk will call the roll.
Representative Swearengin.
Aye.
Jagler.
Aye.
Branchen.
Aye.
Rip.
Aye.
Culp. Aye. Tauken. Aye. Vorpagel. Aye. Sinicki.
No.
Same Ripa.
No.
Call. No. Brostoff. No. Motion carries.
Okay, yes. What?
That-
Oh,
that
different Rob.
Rob with two B's. Rob, don't be so disgusted.
Okay, that will conclude our executive session. We will move into a public hearing. If there's no objection, we'll carry the roll over from the executive session. Seeing no objection, I will convene the public hearing. We'll delay any adjournment of the executive session while we wait for anybody else that hasn't voted. I think maybe everybody has, and there's a couple members that are
Representative
excused.
Onstead is not.
Oh,
He's
Onstead,
in
okay.
another hearing, another meeting.
And once again, if you're here to testify on any of these bills, please fill out the proper slip that's with Scott at the door. With that, then, we'll move into Assembly Bill 721. And I see the distinguished author has joined us. Welcome, Representative Katzma,
Thank you,
and you have the floor, sir.
Thank you, Chairman Sargent. And it's an honor for me to testify in front of this committee, I think for the first time, so thank you.
Well, welcome. A Virgin State Affairs testifier.
Thank you for convening this hearing on AB 721. This is a bill that would entitle the state of Wisconsin to redeem unclaimed monies from the federal government. Under current law, unclaimed and abandoned property, such as the contents of an abandoned safe deposit box, occasionally becomes custody of the Department of Revenue. That term is called escheatment. In most cases, the rightful owner of the property does not make a claim to the property, therefore the property then is auctioned off by the state. However, U.S. savings bonds are not transferable to new owners. Only the current owners or their heirs can redeem these bonds. So if the DOR becomes the custodian of these bonds, the agency simply must hold the bonds until the rightful owner claims them. Today, the Department of Revenue is currently the custodian of a quantity of U.S. savings bonds. There's also an ongoing federal lawsuit that will compel the federal government to inform the states of an existence of matured bonds, and that's worth billions of dollars, and that also is being litigated at this point, and this bill would address that issue then as well. So this bill addresses both bonds that are in the custody of the Department of Revenue, as well as the larger quantity of unclaimed bonds. So first of all, it states that a bond that remains unredeemed for 5 years after maturity is presumed to be abandoned and then becomes then the custody of the state. Secondly, the DOR would spend at least a year attempting to contact the rightful owner, and then the DOR would obtain a court order transferring the ownership to the state. Thirdly, then, the DOR must redeem the bond if the rightful owner does come and place a claim for that. And also, the funds then would be deposited, the proceeds, into the Common School Fund. We've worked closely with the Department of Revenue on some amendments to the bill, and I believe they're going to be testifying later on that as well. So I urge your support of this bill.
Great, thank you very much for your testimony. So when you say custody of DOR, so they're just kind of held there, are they going to like in a separate fund or something until they get dispersed?
These savings bonds are issued in a certain person's name, and currently the DOR has an inventory, has custody of these bonds, but they can't do anything with them because they're specifically issued to a party, and they're deceased, or they haven't claimed, or their heirs haven't claimed those bonds. So there's no process right now to redeem those bonds, and this bill would address that.
Great. I also appreciate you working in the Common School Fund as well. I think that's a good idea. Any questions from the committee for the author? Well, you are off the hot seat early today, Representative.
Thank you,
I
Chairman.
want to thank you very much for taking the time to address the committee today. Next up, we have Nate Ristow from the Department of Revenue. Speaking in favor. Good morning.
Morning.
Welcome.
Thank you. Thank you for the opportunity to testify in favor of AB 721 today, which will establish a process for escheating unclaimed U.S. savings bonds to Wisconsin. This bill provides for more efficient and effective means to handle unclaimed U.S. savings bonds. I want to thank Representative Katzma and Senator Markline for bringing this bill forward and working with the department to develop the language. Currently, 10 states provide for escheatment of U.S. savings bonds, including 4 within the last year, and 7 other states have legislation pending this session. We, as the state, come into possession of U.S. savings bonds through the Unclaimed Property Program, usually when those bonds are left in unclaimed safety deposit boxes. Banks turn over the contents of the boxes to the state when they can no longer locate the owner and the rental fees have ceased to be paid. The unclaimed property program will advertise the name of the owner of the safe deposit box in accordance with the statutes, and we hold the contents of those boxes for 3 years as required, and then we auction off the contents of the box. The proceeds of the auction are kept in the unclaimed property fund. Also, that I use that term, it means the common school fund, which for all unclaimed property is kept, until such time as the owner or an heir claim the property. However, the U.S. savings bonds that are found in these boxes are separated out because they cannot be auctioned and they can't be redeemed by the state under current law. The unclaimed property keeps the physical U.S. savings bonds until the owner of the safety deposit box or an heir comes forward to claim the property. Retaining these physical documents is very inefficient and different than how we handle all other unclaimed property. The physical bond would be given to the owner at the time of the claim. Sometimes the name on the bond actually doesn't match the name on the safe deposit box. You can imagine, for instance, that a parent may keep their children's safe bonds in their safe deposit box. If that's the case, we're never advertising the name of the bondholder because it's been reported to us, the unclaimed property has been reported to us as in the name of the safe deposit box holder or owner. There's never been an inventory of the bonds in possession of the unclaimed property program, but it's estimated that the current amount of bonds in possession could be $500,000 to $600,000 that we have. The U.S. Treasury does very little to advertise unclaimed bonds. This bill would provide the state a mechanism for reuniting bondholders with their property. Under this bill, the unclaimed property program would for the first time undertake an effort to return U.S. savings bonds to the bondholders. DOR would seek to find the bondholder if the bond is unclaimed for 5 years after maturity, and if the department is unable to locate the bondholder within 1 year, the state would be able to escheat, which means to take ownership of the bond through a court action. Currently, we only have custody of the bonds, which for the U.S. Treasury's purposes is not sufficient to redeem them. This would allow the state then, once we have ownership of the bond, to redeem them and deposit the funds into the common school fund, as the Wisconsin Constitution requires that we do with all unclaimed property. The principle of the common school fund is used to provide loans to Wisconsin schools, districts, and municipalities for public purpose projects through the state trust fund loan program. And the earnings, the interest that's earned on that principal also provides public school library aid throughout the state. Under current law, unclaimed U.S. savings bonds are not sent to the common school fund because they just sit as physical pieces of paper in boxes in the basement of DOR, awaiting a claimant. The unclaimed property program would continue to advertise the names of the bondholders after the bond is redeemed and would pay the value of the redeemed bond to a proper claimant should one emerge. And this mirrors the process that we do with all other unclaimed property. So we think this makes a lot of sense. Thanks again for the opportunity to testify on this bill.
All right, thanks for taking time, Nate. You said there's about $500,000 floating around?
That's the estimate. We really don't know because the state treasurer before us, and we have never actually looked through the boxes that we have of these bonds to see how much there is.
Okay. Representative Culp?
Thank you, Mr. Chair. Thanks for coming to testify on this. It's not a question directly related to the bill, just more curiosity for me. You mentioned that the state comes into possession of these bonds when there's unclaimed safety deposit boxes. Is that a matter of just process by banks, or is that a matter of mandate by banks? And possibly Ledge Council would have that answer as well.
It's a matter of state law. After a certain time, any unclaimed property, which would include these safe deposit boxes, we refer to institutions, banks are sometimes these, but as holders of unclaimed property, they're required to report to us anything that has reached a certain point where they've had it for so long they've been unable to locate the owner. Then it's supposed to be turned over to the state. That's basically what unclaimed property is all about. So
I assumed it wasn't haphazard. I just
no,
didn't know the process.
there's a very I can't tell you all the specific years, but there's a specific process that most banks are pretty good about following.
Representative Jacob?
I'm intrigued by this box of, just throw it in the box, you know, that intrigues me. How far back do some of these go? I mean, it's just, no one's ever looked at the box because it's just throw it in the box.
Yes, and it's all filed under again, the owner of the safe deposit box is filed under their name, so if that person or an heir were ever to claim that,
I got you.
then we would pull that bond, but it may not be the same name as what was on that box. So we really don't have an idea of how much is in value there because we can't do anything with it. So for years and years and years, the unclaimed property program's always just kept them and waited for somebody to claim them.
As other states have been moving down this road, is there an ability for you guys to get a total before we move on this to the floor? I mean, or is it?
I think that, I mean, is it possible? Maybe, but I don't know if we'd be able to do it in the time it would take before the end of the session. We talked about it when we first looked at, when this sort of idea was first brought to us. And just the undertaking, after dozens of years of nobody looking at these things, to actually inventory these things, isn't something we thought we would expend resources doing until we had the authority to actually do something with it.
Gotcha. Very good. Thank you.
Okay. Representative Branchen.
Thank you, Mr. Chairman. Sorry, I'm kind of froggy too. I think I am on the bill and I think this has a lot of value, but just for clarification, so after the bonds, there's 5 years and then there's 1 year to contact the owner and then 3 years it will transfer. But say we get past that point and there are heirs, you're saying then as long, if we have this inventory, it can still come back at any time? Is it still left open?
Yes, so just like with all unclaimed property, so right now, when we have the safe deposit box, if it didn't have a bond in it, we'd hold it for 3 years, we would advertise the name of whoever owned that box. If they came forward, we'd give them what was in the box. If they don't come forward in 3 years, we auction off the contents, and then whatever the value was of what we got in that auction, we hold that in the unclaimed property fund. So if somebody ever comes by later, we're continuing to advertise the names, and say, oh, hey, that's my stuff, and we say, well, here's the value of what it was, and we pay them that. It would work the same way with the bonds, where 5 years after they would mature, they would be deemed abandoned. We would then actually look at the bond and figure out, okay, we're gonna advertise this name, no longer gonna advertise it with the box. Do that for at least a year, and then at that point, we could take ownership of it through the court action, then we could redeem it, and then we would hold that value in the unclaimed property in the common school fund until such time as maybe somebody or an heir would come about and say, oh, hey, that's my grandfather, that was my grandfather's property. We confirm all that, and then we say, okay, here's the value of that, that we redeemed it for. I mean, that we
So
redeemed
just for
it for.
clarification, it is literally, it will not, it could go for another 20 years.
Yeah, it could sit there, but in that whole time, then it's still, then it becomes available, which it isn't now, for the common school fund to use, earning interest in order to do the school library aid, being used as the principal as backing for the
It's
financing.
open-ended.
But it's there until somebody claims it, just like all unclaimed property.
Perfect, thank you.
So, let me get this straight. These records are not like digitalized or not on computer or anything?
U.S. savings bonds, they've been.
I mean, when you
since-
get them, you don't categorize them or digitalize them or?
We don't, I mean, the only thing we have is that they are.
I don't mean to get so close, but I can't see around Rob's head.
Again, the only thing we classify them by is what safe deposit box they came in with.
So,
Because that's who, under current law, that's the unclaimed property that was reported to us.
right. So, you literally, they'll have boxes and boxes of
Yes.
these things in the basement
Yep.
of the UR.
We can't do anything, we can't destroy them, that would be,
Right. So, but what if something should happen, like a flood? Then they're all gone.
well, the other portion of this, which was mentioned by Representative Katzma, is these are the bonds we have in possession.
Right.
There are bonds that are referred to as absent bonds, which maybe have been destroyed in fire or flood or something, that have never been redeemed with the U.S. Treasury, but are long past their maturity. And there's the ongoing litigation for states to have access to the list of those persons whose last known address was in their state, who haven't claimed them after so many years. So we could then try and do the same process to try and return them, because again, the U.S. Treasury does very little to try and return, they don't advertise like the state unclaimed property programs do. They don't put out people's names to try and get these bonds redeemed. So that's sort of a side thing, that's down the road. Immediately, we could handle the ones we actually have in possession. But if that were to happen, I mean, we would, if it were to happen now, we don't really know what to tell somebody if they came and said, well, that was my safe deposit box. We'd say, oh, you know, there was a bond in there, but we have no idea whose name was on it, how much it was worth, we just don't know. Yeah, I mean, right now it's, at least with this, we could process a number of those out probably, and actually then just have the funds, which then we'd never, you know, they're just there and available for claim at any time. But, I mean, we obviously take several precautions to protect all of our records at UR, but, you know,
Huge operation like the state of Wisconsin, the Department of Revenue, and they're being kept in boxes in the basement somewhere.
there's nothing we can do with them.
It amazes me.
We can't do anything else with them.
Representative Culp?
Thanks again. I think I want to get in line behind Brett Jagler and Sinicki looking at these boxes, but I think it's the right thing to do. It always makes sense to, you know, to clean out closets, if you will. But is there any possibility at all that the cost to do it would be smaller than the bond? I'm assuming I know the answer, but in other words, the cost of DOR to process this
No.
would be less than.
With the estimate that we have, I mean, again, this go back several years, bonds were issued, you know, a lot during the world wars and things like that, so some of these are probably very, very old, well past maturity. We, you know, if there's $500,000 of value in there, it won't nearly cost us that much to process it, but we also didn't want to incur the cost, even a couple, you know,
Absolutely.
$1,000 to do it if we were ultimately just going to do it for no reason, so.
Okay, any further discussion for the department? Seeing none, Nate, thank you very much for your testimony.
Thank you.
Anybody else here to speak on AB 721? If not, I will tell you then that Senator Marklein has registered in favor. Next, we'll move to Assembly Bill 724 regarding work comp changes. I will bring up BJ Dernbach from the department.
If it's okay with the chairman, could I have the co-chairs too of the council join me as well?
It is okay with the chairman.
Save some time.
Yes, wonderful. So BJ, who's with you then?
I've got two co-chairs, Stephanie Blumino and Jeff Feieringer as well.
Jeff and Stephanie?
Yep.
Did you guys fill out slips? You did?
Yes.
Okay, great. You have the floor.
All right, thank you.
You bet. Thanks for coming.
Chairman Swearengin, members of the Assembly Committee, I'm BJ Dernbach, the Division Administrator for the Division of Workers' Compensation. I also serve as the Chair of the Workers' Compensation Advisory Council, and on behalf of the Council, I'd like to thank you for agreeing to hear today's bill. The Work Comp Advisory Council was created by the legislature to advise the department and the legislature on policy matters concerning the development and administration of the workers' compensation law. The legislation before you today is a result of the council's work over the last year and a half. The language in AB 724 was developed by the council based on input from numerous employer representatives, labor representatives, medical providers, insurance carriers, the legislature, and the department. Following the public hearing, the department met regularly with the council, and on December 22nd, they unanimously passed the council's bill. I will defer talking about the specifics to the two representatives, and I'd be happy to answer any technical questions after they're done.
Okay, great.
Good morning.
Good morning.
Good afternoon, Mr. Chairman and members of the committee. My name is Stephanie Bloomingdale, and I appear to you with you today in my capacity as the chairwoman of the Worker Compensation Advisory Council and in my capacity as the Secretary-Treasurer of the Wisconsin State AFL-CIO, to urge you to support AB 724, a bill designed to protect injured workers and safeguard Wisconsin's respected Worker Compensation Act. Wisconsin's worker compensation system. A little bit about the history. Wisconsin was a pioneer when it came to protecting employees who were injured during the course of their employment. Wisconsin became the first state in the nation to enact a comprehensive worker compensation law. This law, the Worker Compensation Act of 1911, created a system whereby injured workers received prompt treatment, benefits for lost wages, and an incentive to return to work quickly. For over a century, this system has provided employers insurers, and injured employees a stable environment with minimal litigation. Every citizen can be proud of this state's strong worker compensation system. It is fair to all affected parties, and it is admired throughout the country for its stability and efficiency. Research has proven that Wisconsin injured workers heal faster. That means they return to work on average 3 weeks faster than injured workers in other states. Wisconsin's system also has lower costs. According to a 16-state study of worker injury claims by the Nonpartisan Worker Compensation Research Institute, Wisconsin's system does have lower costs. Wisconsin's injured workers are also able to navigate the system effectively, resulting in less litigation, which is beneficial for workers and employers alike. Wisconsin's worker compensation premiums are stable and low, and they have risen at a pace less than inflation for the past 6 years. And this is a very important point to note and remember, that Wisconsin worker compensation system is completely funded by worker compensation premiums. So that means it does not take in 1 penny of taxpayer dollars. I respectfully submit to you today that the historic stability of the Wisconsin worker compensation system is a result of the proven process involved in enacting changes to the worker compensation system. Almost 50 years ago, the legislature, with the purpose of insulating the worker compensation system from politics and to ensure that proper representation of all parties affected by the worker compensation system, created the Advisory Council. The task of this council is to advise the legislature on policy matters concerning the development and administration of Wisconsin's worker compensation law. The efforts of this council provide stability for the entire system and a vehicle to make reasoned changes to continually improve our worker compensation system. The labor and management teams work towards a common goal of recommending changes that benefit the entire system: workers, employers, and insurers. The council process involves expert study, balanced discussion, and thoughtfully negotiated changes to the system. The product of the council's negotiation is then drafted into an agreed-upon bill, which is brought to the legislature. This council process was no different. I can tell you that the council held public hearings around the state and then got to work on studying and vetting proposals. We continued to meet and negotiate through the next 9 months and arrived at an agreement last October. The agreement was quickly sent to the Legislative Reference Bureau for drafting, and I would like to thank Chairman Nass of the Labor Committee and Representative Spiros for taking the lead as authors of this agreed-upon bill. AB 724 provides long overdue increases to the benefits required to adequately compensate employees who have sustained permanent injuries during the course of their employment. Historically, permanent partial disability rates have been increased by the legislature on an annual basis to keep pace with the increasing costs of living. Because of challenges associated with enacting the last agreed-upon bill, permanent partial disability benefits for injured workers have not received an increase since January of 2013. In an effort to bring permanent partial disability benefits current, AB 724 increases the maximum weekly benefit by $20 in 2016 and an additional $20 in 2017. Also, and this is also important to note, that we added a position to the Department of Justice to investigate and prosecute all sources of fraud in the worker compensation system. This Department of Justice position will be charged with investigating and prosecuting fraud committed by injured workers, insurance carriers, medical and health care providers, or employers. It is critical to ensure that all fraud, waste, and abuse is eliminated from the worker compensation system. AB 724 also reduces the statute of limitations for traumatic injuries from 12 to 6 years. Reducing the statute of limitations below 6 years has the potential for causing a wide range of negative impacts to injured workers and healthcare providers alike. AB 724 also provides administrative law judges the authority to use prospective orders for vocational retraining benefits for future courses of instruction or training. The law currently allows an administrative law judge the authority for the employer or insurer to pay for future medical expenses that arise from a work-related injury. However, the statutes do not currently allow for an order requiring an employer or insurer to pay vocationally retraining benefits until an injured worker has actually enrolled and is attending classes. Unfortunately, for many injured workers who have lost their former employment or have no other source of income and do not have the financial stability or income to go to school on their own, this change was necessary so that those injured workers can enroll and begin school. It makes sense to make sure that injured workers get the retraining they need to get back to work. The bill also reinstates Section 10243, sub 5, sub C, which sunsetted on April 30th, 2014. That statutory provision allowed an injured worker to earn part-time wages up to 24 hours during a period of vocational retraining without placing their temporary total disability in jeopardy. Because this provision had a positive impact during its trial period, it was our decision to recommend to you to include that provision in the statutory section and remove the sunset. We don't want to penalize people for working. So in conclusion, I strongly urge you to support AB 724. The proposed changes to the Worker' Compensation Act contained within this bill are changes that are a product of thoughtful study and intense negotiation participated in by all affected parties and represent improvements that will keep Wisconsin worker compensation system stronger and more efficient than any other state in the nation. Thank you very much.
Good morning. I'm Jeff Beiriger, and we've heard a lot about sort of the history of the council. I want to kind of share a little bit about my personal relationship with the council. I have a company that's called Association Management Services. We do exactly what we do. We run associations, among them several in the construction industry. And then also I work with a human resource management organization in the Milwaukee area. So workers' compensation is an issue that's near and dear to a lot of the people that I work with. I went to Workers' Compensation Advisory Council meetings some 24, 25 years ago at the request of my employer at the time, saying we want to try to get a handle, a construction industry employer, we want to try to get a handle on workers' compensation, help us understand how the rates are set, help us understand how the benefits are set. I sat in the audience, and somewhere along the lines I had an opportunity to actually be appointed to serve on the committee, or on the council, and have for about 21 years now. And for about the last 8 or so, I've served as the chairman of the Management Caucus. The one thing that I would share over the course of the 21 years, and then very quickly bring us to this year, is the focus of the council has really been on policy. The people that are part of my Management Caucus come from practitioners day after day. This is what they do as workers' compensation claims and returning people to work. We've got people that are involved in setting how rates are set, reimbursement schedules and such. We have people that indeed are involved in lobbying and negotiating. So there's a number of different skill sets that come, and I think it's important to understand that because there's a 360-degree perspective that takes place at the Workers' Comp Advisory Council between the Labor Caucus, the Management Caucus. We move maybe more deliberately than some people would like at times, but the history for 100 years is such that it allows us to very thoughtfully consider how we want to approach issues and changes to workers' compensation. Now, throughout the history, there have only been 2 times where an agreed bill had failed to move through the legislature in the 2-year cycle. One time, going back into the 40s or so, I can't really speak to exactly what happened there, but more recently was 2 years ago. And what was at issue there had to do with the council looking at medical cost containment and making some recommendations as to how we might address that. The process as a result of that was slowed down, and the bill failed to pass before the session ended. Part of what Stephanie had mentioned about benefit changes that are dating back. Now, there were no benefit changes 2 years ago because there was no agreed bill 2 years ago. So some of that was going back and looking at it and trying to address that. Now, with regard to medical costs, I will tell you that that has been the principal issue that the council has been dealing with for probably the last 6 or 8 years. And we have tried a number of different approaches, including this year, working both with medical providers, through some other councils and committees, where we had an opportunity to try to sit down and figure out something that was agreeable to all, as opposed to having a recommendation that created a lot of controversy a couple of years ago. In the end, we had to make a decision to move forward without a medical cost containment feature, or to go ahead and move with one. And the clear message from people that are involved in the management side of this was, the last time we did an agreed bill, there were a number of very positive changes that were taking place for the system. And if we move forward again and lose all of those changes yet again, then we will have not moved the ball forward at all over a course of 4 years. So the message to us was, please continue to work on medical cost containment, but if you have to take it out now, do it now, come back and revisit that issue, but in the meantime, let's move some other reforms forward. So what are those reforms in terms of management's priorities in the agreed bill? We'd ask for a reduction in the statute of limitations for workers' compensation, and in fact, this bill cuts the statute of limitations down from 12 years to 6 years. We may not be necessarily right where every other state is yet. There may be more work to do there, but we've halved the statute of limitations, something that was important for employers. We also addressed an issue called apportionment, and that basically means that what we want in workers' compensation is the dollars to come in to go to workers who are legitimately injured and who have a loss of earnings or have medical bills that we need to pay. In apportionment, we want to make sure that that portion of the injury that is attributable to that workplace accident is what we're paying for, not for some other injury that may have happened from a car accident 20 years ago, not from the fact that somebody may have a degenerative disease that has nothing to do with their work relationship. So we're targeting the dollars that are going into the system towards truly work-related accidents, and that was important to employers. We also asked that there be a reevaluation of certain disability ratings where medical advances have really kind of changed the game for us. I'll give you an example, is if you were to do a knee replacement surgery today, somebody could actually have a knee that is 100% functional, whereas 40 years ago, 30 years ago, 20 years ago, that may not have been the case. So we used to prescribe a disability benefit based on some sense of permanent partial disability based on it being a knee injury. Well, we're asking the medical community to give us new numbers on that, because if there's no disability, then we shouldn't be paying a benefit, because functionally that person is as good, if not better, than they were pre-injury. So that was another thing. We do chip away a little bit at some of the costs involved in the medical side. We do chip away at pharmacy fees by having a fee schedule for that. We also address some of the maximum of rates for reimbursement. Years ago, when records were photocopied and mailed over to people versus electronically downloaded, there was a cost to doing that in time. We've tried to reflect updates in that as well. One of the other things that employers asked us to deal with was when there is a substance abuse issue on a job, drug, alcohol is causally related to the accident, that more often than not, that's going to result in termination of the employee if there's a policy in place. And so what we did is that if that's the case, then there really shouldn't be a wage replacement in that instance, because the individual would have otherwise been terminated. So we've addressed that by creating language that speaks to drug and alcohol abuse or a violation of a policy and how that affects the benefits an individual would receive. And then the same thing is true on return to work. I'll give you a situation is if someone was injured and came back to work, and a lot of our employers in the state are very good about aggressively returning people back to work. It's good for the employee, it's good for the employer. They bring them back to work, but if they were to terminate that employee for cause, that individual would revert back to getting the benefits that they had otherwise been entitled to, as if they weren't working. We looked at it and said, that's not right. If you're terminated, there's no wage replacement because there's no wage, and so that benefit would be terminated. Medical coverage would continue, but the benefit would be terminated. So those were the main things employers were looking at, among a number of other things that were brought to us, public testimony. LERC brought us issues, self-insured and counsel, DWD, and even members of the legislature. Stephanie mentioned the fraud issue. That was brought to us by the two chairs of the Labor Committee in the last session. So 100 years into workers' compensation, here's what we know. This is not a one-and-done type of piece of legislation. You don't pass it and forget it. You have to revisit it every year because the workplace is changing. We're going to have to deal with issues of people working multiple jobs and how we apportion out disability when you can't work any job, but the accident happened on one employer's watch. How do you do that? And these are changes in the workforce that we're seeing that we're going to have to address and be vigilant on what we do there. But that's the beauty of the council. We meet and we do talk about those things. Late in the session, for instance, the folks from the Newspaper Association brought us an issue and said, we'd like to have this issue addressed. It was too late for us to deal with it. There are commitments that are being made to say we'll bring this up in the next agreed bill. But we're talking about a world that's changed from, people hawking newspapers on street corners to the way that the world works today. The law needs to be updated, and as things are brought to our attention, we do that. And again, I say that with great candor, it can be a frustratingly slow process, but the one thing I can guarantee is that our caucus, and I dare say the Labor Caucus, when we all get together and talk about what's a particular interest to us, we've really taken that 360-degree approach to make sure that we're making good policy here. And then oftentimes we have to do it irrespective of politics. We're just here to offer good policy recommendations. At the end of the day, what we offer here in AB 724, it's the best set of policy recommendations that I've been involved with for more than 20 years. I think it's a good bill, and I urge you to support that legislation.
Thank you very much, Jeff and Stephanie and BJ. So I think the key takeaway here is this is the agreed-upon bill through all of your mutual efforts. So, any questions from the committee for the three people testifying?
Mr. Chair,
Representative Siddiqui.
I just want to thank the council for their hard work and diligence in getting us a bill this session. Thank you for all your hard work. I know a lot goes into it.
Thank you. Representative Call.
I also want to thank you. I know it's a lot of work, not always fun. The DOJ position, Stephanie, how's that funded?
That's going to be funded, it'll be a position that it'll be part of the insurance assessment, so part of the cost of the workers' comp system. So no GPR, it's going to be, I guess, the fiscal bureau would score it as segregated. Okay.
And I don't know what the numbers are, but in terms of, you're spreading over a base of, I don't know, it's $1.6 million, $1.8 million in premium or something like that, that cost ends up being, quite negligible over what effect it would have on rates that are paid. It's such a large base that small amount really isn't affecting rates significantly at all.
And then real briefly, you indicated the Newspaper Association,
You
ran out of time to address.
There was an issue that was brought to us very, very late, and in fact, on the day that we were agreeing and actually voting on the final bill, it's something that we had just a moment's time to really look at. And typically what we'll do is public testimony's heard, we'll have other information brought to us, but to try to address it and turn on a dime and include something, it just didn't give us enough time to do that sort of deliberate review. Ultimately, I think, management has said that, we'll certainly bring that up and make that part of our proposals for next year, so it will get a full, discussion at the council next year. Whether it's included or not in an agreed bill is really a process of that discussion and negotiation, but really more than anything else, the issue isn't anybody saying no. The issue is we just need more time so that we can do that thorough evaluation and go from there.
Okay.
And we'd be glad, we've got a memo from the department that if the committee would like, we could distribute that, at least from the department's perspective, that the issue was solved by a 2011 LERC decision that currently is binding on the department, that issue, the way that program is set up and what the Newspaper Association's goal is currently happening. that is just not reflected currently in state statute, but practically from the department's side, that's how we're interpreting it right now.
Okay. Any other questions from the committee? Seeing none, thank you very much.
Thank you.
Next, we'll have Chris Reeder and James Buchan from WMC speaking in favor. Welcome, gentlemen.
All right, thank you, Mr. Chairman and members of the committee for having this hearing today. Appreciate the opportunity to talk about workers' compensation. My name is Chris Reeder. I'm the Director of Health and Human Resources Policy for Wisconsin Manufacturers and Commerce. Wisconsin Manufacturers and Commerce, as you know, is the state's largest trade association. What you may not know is our history with workers' compensation. We were actually formed, the original organization that later became WMC was formed in 1911, the same year that workers' compensation became law in Wisconsin. There were a number of different laws being moved forward by the legislature at that time that made some business leaders decide to get together and make sure that they had a voice in Madison. And so we have over 100-year history with workers' comp, really back to its inception in 1911. With me today is James Buchan. James is WMC's representative on the Workers' Compensation Advisory Council and has been for a couple of decades, and he will be happy to answer some questions and give some comment as well in a little bit here. I won't belabor too much on the bill because you heard a lot of the points in it from Jeff and from Stephanie and from BJ. But I do want to just make it clear that on behalf of our 3,800 member companies, we do support the bill. Obviously, as was mentioned, it's a negotiation process. No side gets everything that they want in a negotiation. Certainly that's the case here. That being said, it is a very strong bill, and we believe from management's perspective contains some really good reforms. And as Jeff said, is probably the best package to come out of the council process in a number of years. I just want to highlight a couple of those reforms. Mr. Viger already talked about some of these. I just want to highlight the fact that these are the kind of the reforms in the bill that really make us think it's a really good bill. The first is apportionment of permanent disability. Again, making sure that an injury or that an employer is responsible only for that part of an injury that's actually caused within their work, at their work site, and not a prior injury. Misconduct or substantial fault. What the bill does in this area is it brings some updates that the legislature passed to unemployment insurance when it comes to misconduct and substantial fault for terminations. Brings those definitions also into the workers' comp realm so that there's some consistency between chapters 102 and chapter 108, where if somebody is terminated because of misconduct or because they were at substantial fault for violating something in your employer handbook, that their benefits would not continue because they were terminated for good cause. Violations of an employer drug or alcohol policy. Again, if you're an employer and you have a written drug policy, this bill says that if the worker is injured and their injury is because of that violation, not just that they were violating the drug policy, but that was causal to the fact that they were injured, that would also mean that they would not get indemnity benefits. And importantly, only indemnity benefits. We're not talking about the medical treatment side of it. Traumatic injuries, it was mentioned that this bill reduces the traumatic injuries statute of limitations from 12 years to 6 years. That is certainly great progress. It means that Wisconsin is no longer the last state in the nation. We were the outlier at 12 years. The next closest state currently is 6 years, so we moved from kind of last place to tied for last place. Certainly there's progress to be made here. Most states are at either 2 or 3 years, but cutting it in half is great progress and something that I think should be applauded. The council should be applauded, and we'll continue working on what we believe is the right movement of lowering that in future years. Minimum permanent partial disability ratings. Jeff mentioned this one as well, how an injury today, the treatment to that injury might have better results than what 40 years ago would have yielded. And so in current law, you know, it's set out very specifically that if you have a specific injury, that you get X% disability rating. And what the bill sets up is a process by which medical practitioners will take a look at those, basically at modern medicine, and update the minimum partial disability rating to reflect what modern medicine provides. So that if you have a knee replacement, you know, today's knee replacement isn't the same as one from several decades ago. So it really just modernizes and reflects modern medicine within the statutes. And then fraud investigation, that was brought up also. What this does is it really mirrors, again, what was done in unemployment insurance, where it takes and authorizes the Department of Workforce Development to bring DOJ into investigations, and it allows them to request DOJ to do prosecutions if the local district attorney is too busy to take up such a case. In doing so, it also funds that provision, just as unemployment insurance did 2 years ago. So because of these reforms, and certainly many others in the bill too, WMC supports the bill. We encourage you to support it and move it forward to the full assembly. In addition to what is in Assembly Bill 724, however, I would be remiss if I didn't bring up just briefly an important issue that is not in the bill, one that we certainly tried to bring into the bill and were unable to get across the finish line, and that being something to deal with high medical costs. According to the Workers' Compensation Research Institute, WCRI, which is an independent, not-for-profit research institute based out of Massachusetts, and they have a researcher that actually is based out of Wausau that does all of their Wisconsin studies. Wisconsin continues to have above-average medical costs for workers' compensation. In the last report that they did for Wisconsin, which was released last October, they found that Wisconsin's medical costs have risen faster and are now higher than most states that they took a look at. They attributed nearly 75% over the last decade, 75% of the increase of workers' comp costs is attributed to the medical side of the equation, and 46% higher per claim medical costs. They found Wisconsin has currently 46% higher per claim medical costs than the average state that they looked at. Left unchecked, we're just concerned that these high medical costs, which really have kind of changed the dynamic of workers' comp and where the dollars go. It used to be about 50 cents on the dollar paid for indemnity and 50 cents paid for medical. Today it's about 70-30, a little bit under 70 cents on the dollar goes to the medical side. We're concerned that left unchecked for too many more years, that these high medical costs will threaten to undermine the competitive and generally positive workers' compensation system that we have in Wisconsin. At some point, that will be reflected in insurance rates, and it's just something that we would encourage the committee and the full legislature to take a look at moving forward. It's something that we will certainly keep looking at internally within our broad membership, and hopefully in sessions to come we can address high medical costs. While AB 74 does not address that, as I said before, it is the #1 issue that we actually hear about from our members. And so again, I just encourage you, one, pass this bill today, but keep an eye on high medical costs down the road. Something that we should keep talking about going into the next session. So thank you for your time today. I'll be happy to answer any questions, but first I'll ask James Buchan to.
Thank you. Thank you, Mr. Chairman and members of the committee. I'm James Buchan. I've been on the the Workers' Comp Council for 28 years, 25 of which I was in-house with WMC as their senior vice president. In the last 3 years, I've been a consultant to WMC as well as others, but I continue to serve on the council representing them. This process that we've talked about today of making policy has served Wisconsin for more than 100 years, going back essentially in one form or another to the inception of the workers' compensation system in 1911. And it's widely credited as being the reason why we have what is viewed as a model program around the country, with a few exceptions. And part of that it results from the fact that this system does a lot of things, but one thing it definitely does is create sort of a stable workers' comp environment. Policy doesn't swing wildly, depending on the sort of political winds in the capital, but remains relatively stable. And you know, at the end of the day, this is an insurance program, so it's really about buying insurance policies. And the insurers benefit from stability, and it helps keep insurance costs down. And we have a very competitive market in this state in the sense that we have more than 300 companies that write workers' comp insurance in Wisconsin, which is not the case in many places. There are states where virtually nobody wants to write the policy, and it really becomes a government program as a result. So I think that has really served Wisconsin well. I think our system provides fair benefits at a reasonable cost to employers. Our premiums presently, or in the last analysis that I've seen, rank 23rd on our average premium, ranks 23rd in the nation, so right kind of in the middle. And there's a number of positive features. We have, low litigation rates, a very robust return to work experience, I guess you'd say. A lot of that has to do with, employers really embracing that concept. And we've been able to preserve the exclusive remedy in Wisconsin almost completely, which is to say that employers are shielded from being sued, even if they're completely at fault for the work-related injury. They can't be sued. Workers' compensation becomes the exclusive remedy. The biggest issue, as Chris pointed out, is healthcare costs. And the point there is that by and large, people pay charges. It's one of the few places where what you're charged by a health insurer or a healthcare provider is actually paid. Almost everywhere else there are substantial discounts. It becomes very difficult to do that in this system because you can't direct care. It's a system where the injured worker gets to choose where they get their health care. As a result, our health care as a proportion of the total dollars spent for workers' comp, health care constitutes 70% of it. And that's just about the highest in the country, if not the highest in the country. The average nationally is about 50%. So in other words, for every dollar spent in workers' comp in the average state, only 50% of it is going for health care. Here it's 70%. We clearly have an issue that needs to be addressed, and hopefully in the future we'll have an opportunity to do that. Thank you.
Thank you very much. Any questions for the folks on WMC from the committee? Seeing none, gentlemen, thanks for coming to the Capitol.
Thank you.
Appreciate it. Anybody here else to testify on AB 724? Okay. If not, registering in favor, Representative Wachs, Teresa Elliott, Ronald Kratt, Andy Franken, Scott Stenger, Brian Dake, Mark Rail, and registering against is Jeannie Ogden. With that, we will move to Assembly Bill 779. I will ask Representative Gagler to take the chair.
So we start with 633.
AB 633. Aye.
641. Amendment 1 on 730.
Yeah, exactly.
I think it feels down here.
Yeah, well, it's a long way from down there.
I know, that's why I have to like,
Correct.
Representative Swearingen, whenever you are ready, sir.
Well, thank you, Temporary Chairman Jagler.
Put your cell phones on stun.
Yes,
I always want to say
exactly.
that.
Exactly. I want to thank you for the opportunity to address this committee, and what a fine committee it is, I might add. You have my written testimony. I'm going to forego the testimony. Basically, Assembly Bill 779 just brings the business of pawnbrokering into the technology, the high-tech technology world that we're into today. So currently in the state of Wisconsin, if you pawn your watch, for instance, and you agree to a amount of time that the item is to be pawned, At this point, 30 days prior to that time limit coming up, the pawnbroker or pawn store must send you a registered letter via the United States Postal Service indicating that your time is up in 30 days. All Assembly Bill 779 does is bring us up into this century in saying that you may send a text or an email in lieu of a registered letter. So as much trouble as the United States Postal Service is in, I hate to add to that with them, but we are just making the pawn stores able to do their notices by electronic means. I might add also that the person who is putting the item up for pawn must agree to this. So therefore, they must have a cell phone or computer to be able to accept these messages, and this should help out this industry. With that, I'd be happy to take any questions, although I do know there is a member of the one of the pawn stores in the audience and will be testifying after me.
Any questions from committee members? Representative Branch?
Thank you, Mr. Chairman. Just for clarification, I know that it's up to the individual to provide the right information, but is there, in the event that that it comes back, the text or either one come back, is there some sort of statute that will allow them to then do a third-party thing?
So-
Or carriers drop things, I'm saying in the event. yeah.
Right, so you're saying arguably if they provide an erroneous text address or
They provide something
email?
and something happens, the phone, the email, the service, something happens.
So the registered mail would obviously always be the fallback?
That's what I'm asking.
Yeah. So as far as I know, this bill does not change that.
Okay. Would it be able to have some, would you consider having?
Sure, yeah, we
a
can check on it
third
just to make
party?
sure.
Absolutely, thank you.
Any other questions from committee members? Very good. Gavel's yours again, sir.
Thank you very much. And next, we will call up Todd Phelps from Pawn America, speaking in favor. Good morning, Todd.
Good morning, Mr. Chair.
Thank you for coming.
Thank you for having me. I represent Pawn America, which owns and operates 7 pawn stores in the state of Wisconsin. I'm here today to speak in support of Assembly Bill 779. In a nutshell, we view this as a technical amendment, as the chair said, to bring existing law into the 21st century, which would allow pawnbrokers and its customers to provide certain notice via email and text messages. Currently, as the chair indicated, pawnbrokers are required to send these notices via registered mail. And in operating in Wisconsin since 2007, we've found this to be both impractical and frankly ineffective and costly. Our experience is that over 20% of the registered letters get returned as undeliverable, and so this really isn't achieving the underlying purpose and policy of the notice provision. This also is an extremely expensive and administratively burdensome process, again, to not really effectuate the legislative intent. Lastly, we think that this amendment is consistent with other sections of Wisconsin law that allow for electronic notification. So with that, I'm happy to answer any questions.
Well, thank you again for taking time today. Wisconsin's unusual in this, right? This is done pretty much on a lot of other states already do this?
Yeah, so typically in other states, when we operate in 4 states, and other states, there's actually automatic forfeiture with no notice, and so Wisconsin is quite consumer friendly in that regard.
Any questions for Todd? Representative Zinn.
Thank you. I'm completely unfamiliar with pawn shops. So in this bill, this is just adding another, I'm sorry, what was that?
You're missing out.
A potential customer.
So in this bill, this is just adding another, you still got to do the registered mail?
No, this would be in lieu of it.
In lieu of it.
What we know about our customers is that our customers tend to move their physical addresses, but they tend to keep their email and cellular addresses. And so because we do communicate other ways with them through, marketing and promotional materials. So no, this would be a menu of options in which they could choose to get notified.
And how long before you have, how long do you hold stuff for before you either resell it or notify them? I don't know how it works.
Sure. It's 30 days, and then we have to hold it another 30 days from sending the notice.
And now, I guess I have a concern because I understand, people move around a lot. And that's I guess that is really the nature of what kind of people need to go to pawn shops to pawn their stuff. I mean, I'm not criticizing you. You've got a business to run, but, and you provide a service. But most people who have to go to pawn shops, I mean, they're living day to day. Like, for instance, their cell phones. I mean, they probably have like a pay-as-you-go thing, and if they can't pay it, how do you notify them? I'm just trying to figure this all out.
Sure. So we've been doing this for 25 years now, and we operate over 30 stores in 4 different states. We know a lot about our customers, and what we do know is that they do tend to keep their email addresses and their cell phone numbers current. They could certainly elect to have whatever mechanism they think would be the most effective for this notice. But like I said, we're getting about 20% returned in the mail system, and that just simply hasn't worked. And I don't know that it's so unique necessarily to our customer base. I mean, I think to myself about my own circumstances, and I've moved my physical address a lot more in the last 10 years than I have. I haven't changed my email or my cell phone number in the last 10 years. So I think really this is simply recognizing what is true in today's modern age, and that is that we can be reached electronically, frankly, more effectively than we can through our mail.
Representative Rip.
Thank you, Mr. Chair. Just wondering, so whether we do the certified mail or the electronic, you're basically just giving them notice. There's no reply necessary between the other party, correct? Okay. And then, do you generally keep track of how many come back to redeem items or actually allow you to sell it? Do you track that at all or not?
We do, it's roughly, it varies depending on the item and the loan amount and the location, et cetera. But anywhere between 40 to 60% of the customers will actually redeem the item. So.
Really? Thank you. Representative Branchen.
Thank you, Mr. Chairman, I appreciate that. And I'm just trying to find a comfort level, so will it be an email and a text, or one or the other?
It would be one or the other. Again, it's really the customer can elect that. When they come in, they fill out.
Which method would work?
Right, and we make it a checkbox.
So you understand my question. I'd say I probably get 99% of my emails and text. But guess what, occasionally that's the one you miss. Or so if something bounces back, are you gonna have a policy to send it one more time? Or,
yes.
And I mean, it is really consumer friendly. I mean, I understand what you're saying. I mean, you really don't have an obligation. You've created a transaction, you've created an agreement, and that's the end of it. And your ability to give them one more chance to make a determination is really very customer friendly. So I'm sorry, go ahead. So my question to it bounces back, and you would get, the text that said undeliverable. Do you have something? Could you have something in place?
Sure. In discussing this with our owners and managers, we realize that pretty much no system is going to be 100% foolproof. Right. So how do we, as a policy, one of the items we've discussed doing is to, as the customer standing there, to actually send the email or the text to confirm up front that that's a valid address and that's a valid number. And presumably, 30 days later, again, there's probably some risk that there's not, but we think we'll substantially reduce that from the current 20% return down to, less than 1%.
So, but that's not in here, that's just a policy decision that you think you're doing?
Correct.
Okay.
There's a benefit, by the way, too. There's you know, like all businesses and all clients and constituents probably even, there's a benefit to reaching out to your customer, to having that connection. We do things the right way. We treat our customers extremely well because we want them to like us and come back. So, so with that, I mean, there's an incentive for us to connect with them. We just think that the current regulatory scheme is ineffective and expensive.
In full disclosure, my wedding ring of 27 years is from a pawn shop.
As is my wife.
So I understand the value and the quality of the work that you do. So it's not going to be in here as policy. So you're going to do going
You get a good deal on it.
You got that right. College kids aren't stupid. That being said, so it's not going to be in here. It's just going to be your policy. So there's no and you understand that you get a name wrong or you get a number wrong. It's so easy to happen in that process, especially if you're kind of emotional about having to make a choice financially about something that you want to do. So it's not. I mean, would you be okay if we made it part of the bill that it has to, or is that not part of?
That there would be some sort of verification of it. Yeah, I mean that seems to make some sense. Yeah, like I said, as the customer standing there, you know, to just ping them with either a text or an email seems like
easy enough.
Yeah.
I appreciate that. Thank you.
Thank you. I just want to follow up on Representative Ripp's question about, you know, the return receipt. If you send it registered mail, you get a return receipt that they received it, correct? So, under this new plan, you don't get any kind of confirmation that they got the, I just want to confirm that. I'm just trying to figure this out here. So if you send them an email or a text,
Sure.
how do you have proof that, how does somebody prove that they did or did not get that?
Yeah, it's a great question, and that would not be part of it.
So that would concern me.
Well, that's why I said if we put it in there that they'd have to do it right there for policy, it would allow them to ping their phone or ping their ability so that they could see that it actually is correct. That way they have the right information going on.
I don't know what a ping is.
So I call you, I text you right now and it comes up and so we both agree it works.
Okay.
Get it?
Got it,
That's
okay.
Sorry.
I turn it on and it works, that's all I know.
Any other questions for Todd? Seeing none, then I will say if Mrs. Vorpagel is listening on the Wisconsin Eye, that the representative said, geez, I wish I would have thought of that when you mentioned your ring.
I'm going to be in trouble.
Thank you very much, Todd, for your time.
Thank you very much.
You bet. Anybody else here to speak on AB 779? Seeing none, then I will say that Representative August is registering in favor of the bill. We will move now to AB 800, having to do with fantasy games and providing a penalty. I will bring up the author, Representative Vorpagel.
Well, thank you, Chairman Swearingen and members of the committee. I have some written testimony that is working its way around. So thank you for holding a hearing on AB 800, the Daily Fantasy Sports, or DFS, as I'll refer to it throughout my testimony back and forth, bill, which was introduced in a bipartisan fashion. So thank you very much to my colleagues who signed on and introduced with me. So I'd like to start off my testimony by saying that AB 800 isn't legalizing something that isn't currently going on in Wisconsin. What it does is provides clarity and consumer protections to an activity that people currently enjoy participating in. In my testimony, I'll cover a few things, how we got here today considering this bill. In other words, a brief history of DFS and why I feel it's important that we seriously consider this legislation. Briefly describe the bill and issues it's intended to address, and never missing an opportunity to have a captive audience, try to and do a little education with folks. I have some slideshows towards the back, and we can walk through some of the technology to help folks who may not be daily fantasy players understand how it works. And also my thoughts on why this should be considered a game of skill and how it differs from gambling from a personal experience. or personal experiences. I anticipate there'll be plenty of questions, so I'm happy to address those as best I can. I know there's some folks testifying later from the industry who may be better able to answer some of your questions, and certainly we'd be happy to follow up as needed. So how do we get here with this bill? I've been a fantasy sports player for many years. I remember learning about and playing a kind of simple rudimentary game with my dad and my brother back when I was in grade school, and we probably played for our stakes were probably who set the dinner table at the end of the at the end of the game. But so this is something that I've been interested in. Have played fantasy football and baseball games, and really started taking an interest. Most of those have been kind of the week-long variety is the term for what everybody traditionally thinks of as fantasy football or their league with their buddies, things like that. But I started taking an interest in DFS over the summer when, and it started kind of looking at it without necessarily a particular legislative agenda or issue in mind, but just kind of to learn about the industry, especially as we were seeing more commercials and advertising, things like that, on TV. Then as I was in the process of doing that, I've also included a Wall Street Journal article from October titled "Storm of Criticism Engulfs DraftKings and FanDuel." And briefly to summarize, the issue was an employee from one of the companies was alleged to have used data from one of the sites to play on the other site, and that sort of got me thinking, well, you know, is there a consumer protection side of this? And secondly, some of the New York Attorney General's efforts to prohibit DFS in New York made me realize that this is sort of a new uncharted territory. And I think it would be important for the state legislature to weigh in and clarify some things. So daily fantasy sports have been around for more than a decade. The first DFS site sprung up shortly after the Federal Unlawful Internet Gambling Enforcement Act, UIGEA, which was signed into law in 2006. And that bill essentially was put forward to address online poker. UIGEA also defines what a bet and a wager are, and more importantly to our discussion today, defines what a bet or a wager is not, including participation in fantasy or simulation sports game. Our definition that we've used for AB 800 of fantasy sports game comes from the federal UIGEA definition. And while the UIGEA is a federal bill, it is clear that it doesn't preempt state laws regarding gambling. And I feel that because of some of these recent news stories and actions of attorneys general in other states and kind of the broader evolution of people's participation and interest in fantasy sports, that this legislation should be discussed. And we should address through legislation the legality of these companies to operate in our state, as well as, again, like I said, some basic consumer protections. Of course, we're all seeing the fantasy sports industry booming. There's podcasts like ESPN's Fantasy Football Podcast, CBS Sports Fantasy Football Today, and even just casual observers of sports will notice there's direct fantasy coverage throughout the week in fantasy football or in pregame shows, who's in, who's out, injury updates, those sorts of things. Folks are paying much more attention to. And then ESPN even has a fleet of fantasy reporters and analysts who keep players up to date on all the latest information that's going on. And even there's a Madison-based company called RotoWire who employs 27 people just up the road here on Regent Street. So there's certainly a economic component to it as well. The president of the company, Peter, I believe is here to testify later, and they basically provide statistical analysis and news for fantasy sports enthusiasts. So AB 800 in today's hearing, this bill would require fantasy operators to register with the Department of Financial Institutions and impose certain requirements on fantasy game operators. And you'll find those in 570.10A through H. And I'll just maybe point out a few of those. So it would prevent employees and relatives from living in the same household as a fantasy game operator from competing in fantasy games where the prize is over $5. That sort of addresses the Wall Street Journal article. It would prohibit fantasy game operators from participating in fantasy games that they offer, prevent employees or agents of fantasy game operators from sharing personal confidential information with third parties, verify the game participants be 18 years of age or older. And then I also included another news article that deals with a smaller DFS site that recently went out of business, and the customers' accounts were basically paper and not, they couldn't withdraw the money that they had in the account. So this would require that they segregate game participants' money from operational monies, maintain reserves for those accounts in cash equivalents, irrevocable letters, bonds, that sort of thing. And then finally, the requirement to have a third-party audit to ensure that they are complying with this law. It also defines a fantasy game, and the definition is being a fantasy simulation sports game or educational game contest in which all winning outcomes reflect the relative knowledge and skill of fantasy game participants and are determined predominantly by accumulated statistical results of the performance of individuals, including athletes in the cases of sporting events, in which the outcome is not based on the score. So it's not a point spread or a score, an accumulation of the single game. A point spread, performance of a single team or combination of teams on any single performance of a single athlete or player in a single event. So it's a broad. It's defining that you have to assemble a team and it's not just more on the performance of one player, one team. Green Bay versus Dallas, picking the who's going to win or beat a point spread or things like that. Furthermore, AB 800 specifies that a fantasy game is not betting or lottery in the state of Wisconsin. I guess many people on this committee are familiar with weekly fantasy sports, and some probably play in leagues with family or friends. And a recent study actually has shown that over 900,000 Wisconsinites have an interest in play fantasy sports, and that estimate is 55 million people nationwide. So we've certainly seen folks take their love of sports to partaking in this activity, and especially more recently have shown interest in daily fantasy sports, which is a similar concept to the week-long or season-long games, but instead of committing for a full season, you can do it on a individual game or a game or individual week basis. So I'd maybe like to just take a minute to walk through. I took some screenshots of a game that I participated in this weekend, just to kind of understand the technology a little bit. So first slide, you have the home screen that shows kind of all the different sports that are out there, or that this particular fantasy operator provides for, and then the different types of games that you can pick from. On the second slide, the third slide, one important thing that I would like to point out is when you play a game, you perhaps pay an entry fee. So unlike gambling or placing a bet in a card game where you can, if you increase your bet, you increase your payout at the end. This is an entry fee where then, as we look through to slides to the second page, there is the bottom two slides. Then there's a winning payout structure. So you don't, by betting, there's no option to bet more and potentially receive a higher payout. You're basically paying a fee to join a game. Then it just kind of outlines some of the functions of the site. There's a menu on there that talks about how the rules, so everybody knows the point system, and it's very upfront and transparent. And then kind of goes through the process of selecting your team. One thing I would note about daily fantasy sports is it's salary cap based. So you get, in this case, a salary cap of $50,000. The players are rated based on their abilities and their past performances, things like that. So the players who have who are likely to score more points have higher values associated with them. And everybody, unlike in a weekly fantasy or where you'd have a draft at the beginning of the year, everybody has the same opportunity to pick the same people. It's not like a situation where if I select somebody, Representative Brostoff, who may be playing the same game, can't have that person. He has the ability to choose that person. So you're using your skills and knowledge and research to assemble the best team that you think is going to have the best outcome. Then it just goes through some of the statistical analysis and actually selecting players, some of the updates on news injuries with Rob Gronkowski with some news supplied, which was supplied by our friends here locally at RotoWire. And then the last, the page 7 just kind of shows after you have your team assembled, you submit your entry, and then how throughout the course of the game, because games aren't always played at the same time, like NFL games in this case aren't always played at the same time. It shows your team in this case on the left side, and then somebody who's playing the same game blocks out their who hasn't playing or isn't in the game yet, so that you can't go back and change your lineup to game the system. Once everything's locked in, it's locked in, and then at the end, just kind of some other statistical analysis, just as an example of things that people look at when they're creating their teams. The other important thing that I would note is the games are when you join a game and pay your entry fee. There's already a predetermined payout structure or prize structure. So it doesn't matter if one person joins the group or plays the game, or the whole thing fills up. You still, if you're the only person in there, you would be the first place winner. So it's I guess a guaranteed payout. Unlike gambling, where you can lose, have risk of losing something. Let's see. Oh, finally, the debate on being a game of skill versus gambling. First of all, you can see the amount of statistics and research that are done when playing fantasy sports. Secondly, in order to participate, we talked about earlier the entry fees and the predetermined pay schedule. And thirdly, DFS, we talked about in daily fantasy sports, everyone has the opportunity to choose the same players. And finally, something that's interesting to just take note of is organizations who have typically taken a hardline stance against sports betting, gambling, things like that, Major League Baseball, NFL. We recently had Pete Rose kind of resurface back into the news, are partnering with DFS organizations because I feel, for me, I see myself no longer as just a Packer fan, but also interested in watching other games that may be on Sunday, or kind of take interest in more than just one single team. So I think they would feel that it has an opportunity to broaden their audience as well. But thank you very much for your attention, and I'd be happy, like I said, to answer any questions anybody has.
Representative Jagler.
Thank you, Representative. I'm having a hard time taking anything you say seriously after your Carson Palmer selection.
I was going to say, as you can see, I did not do very well with this lineup.
What's your biggest incentive for this bill? Is it the consumer protection angle? I mean, I'm trying to get at where we're at here.
kind of two things. One is the ability for what's currently going on, sorry, what's currently going on for companies that are providing this to have certainty that this is a legal activity, and then also some, what I think are basic consumer protections.
Representative Call?
Thank you. Do you know, you've done a lot of research, this is very helpful. Do you know what other states are defining fantasy sports as not being gambling?
There's been an effort, Florida, Illinois, I would say more states than not are currently looking at some sort of structure like this and defining it not as gambling. I can't speak to specific bills just because everybody has their own state
But
laws.
if somebody in the industry can maybe get us something also along those lines, probably from somebody in the industry, what states currently consider these to be illegal? That'd be helpful just to understand. And then I've got, if I could, a couple that are probably more for Ledge Council, I'm gonna guess. It's not a concern, but a question. Could this be construed to conflict with the Constitution? And if so, what ramifications would that conflict have on our tribal compacts, the legal and financial ramifications?
Sure. There is a constitutional provision in the Wisconsin Constitution that generally prohibits the legislature from permitting gambling. There are a few specific exceptions that are given in the Constitution, such as a religious or charitable organization to be able to have raffles and bingo, and then a few other exceptions from that. Gambling is not defined, though, in the Constitution, so that has been basically left up to the legislature, and there is a chapter that addresses that and defines betting and the lottery and so on. And at least one court case has looked at those definitions and the weight that those definitions place on chance, even if there is a certain amount of skill. And so the test that would be used in Wisconsin is, what is the dominant factor? Is this going to be a game of chance or a game of skill? And that would be up to a court to review and determine.
And Representative Call, obviously, this is something that, I looked into and spoke with Ledge Council, and the other thing in drafting this is nobody has yet been willing to kind of give a clear, this is, this isn't, it's kind of the legal world that's out there. I sent, some of the tribes, Potawatomi, Ho-Chunk, Oneida, had early versions of the bill before it was released for the co-sponsorship. So I've been trying to keep them involved and taken to heart. I haven't received any concerns that they've had with it. And I've been, very open to working with them, because I don't want it to be about, like I said, legalizing something that is currently not going on, but more just make sure that what is currently allowed, people know that they're, the companies offering the service and the people who are participating know where they stand.
Yeah, if I could, I want to be clear. It's not that I would be opposed to what you're proposing. I'm concerned about the financial ramifications potentially if we don't have a clear answer going in.
Mm-hmm.
And what I just heard from Ledge Council, and I've been practicing law for 20 years, is that's not a clear answer. And we're at the mercy, that's why we did the amendment early on that unfortunately failed on the recycling thing. You're at the mercy of hundreds of circuit court judges, 4 district court of appeals and the Supreme Court, if you don't clearly state it in the law. And that's what my worry is here, is this could be tied up, because this would be something that would go to the Supreme Court. And so I get a little concerned about that, and I'd want a clear answer from Ledge Council, because the legal and financial consequences could be fairly significant for the state. The other question I have, if I could, for Ledge Council is, we're defining now games of skill. Could other forms of gaming that have been interpreted as gambling in the past now fall into that definition? Because it's not that limited, it's fairly broad.
Well, the bill is specific to the fantasy gaming and under that definition. So somebody would have to make an argument and convince a court that because that is the case for fantasy gaming, that should also be the case in their case.
Right.
But because there's the general constitutional prohibition, that would be an uphill argument.
That one would be more uphill.
That would be more, yeah.
My bigger concern is the latter. Okay.
And I think some folks from the industry again would have more, dug down into the where it falls on the line of skill and some of those questions that Ledge Council talks about.
Are those folks from the industry confident enough to indemnify us if we lose our gaming revenue from the tribes?
I'm not saying that they'll get definite answers, I'm just saying they may in their testimony or be able to follow up with.
I understand, Tyler, I'm not opposed to this. That's a huge financial situation.
I agree, I'm with you. Margins.
Well, Tyler keeps betting they will.
Thanks, Mr. Chair. Do we have an indication from DSPS as to how much the regulatory scheme would cost for this?
DFI would be the regulating entity. I don't believe that we got them a fiscal back then. No, we got fiscal back, yeah.
And one of the concerns I have, the legislature, I think, has deviated from what the business climate should be here in Wisconsin by way of what our bureaucracies do. Our bureaucracies regulate business, I hope to the least extent possible, but we are setting up an exorbitant license fee for these businesses, and this is without talking about the constitutionality, right or wrong on gambling. I'm just talking from a pure business perspective, setting up a regulatory scheme that seems to me to be a fence for competition or government overreach in charging a licensure fee that far exceeds the cost of regulating the industry. Can you speak to?
Yeah, I appreciate that, and I know we kind of talked about this. And yes, I would be very willing to adjust based on the cost and making sure we're covering our cost of a regulatory of covering, narrowing it to just cover the costs of the regulatory functions. Where this particular fee schedule, I guess, came from was a bill similar to this is making its way through the process in Florida that called for a $500,000 initial fee and I believe it was $150,000 annual fee. So we kind of population sized it, I guess, to Wisconsin. That was sort of being perfectly honest, the number came from, and anticipating there would be regulatory costs, and not, at the time when we put the bill out, had what specifically or how much those would be. But I'm open to working on it further.
Okay, Representative Branchen.
Thank you, Mr. Chairman. And I think I echo, thank you for coming in, and you've obviously put in a good bit of work on this, but I think I'm going to echo some of the concerns as, we have the AG giving us a declaration on this, skill versus luck. You have Gronk on here. What's a healthy Gronk versus Gronk with a bad knee? I mean, there's luck to this. Injuries being the number one thing, and the fiscal estimate. And I guess the other thing is, I am concerned about fiscal estimate for being able to regulate this. I mean, I know you've done a good job here, but checking households to see if somebody works on another within the same family, if it's a $5 payout versus a multiple, verifying that the participants are 18 years old. I mean, there could be a lot of regulations.
So to address that last item, the onus would be on the daily fantasy operators to control that aspect and keep the players out. And then that's why the auditing component, and then there's a penalty structure associated if they don't follow the rules that we're providing for in the bill. So it wouldn't be the government regulators necessarily having to weed through all that paperwork. It would, the onus would be on the company to set up those policies.
But for clarification, we're setting up a whole new corporate structure and with penalties and with regulations that we haven't touched before.
Correct.
Any other questions for the author?
Yeah, me.
I did not. I apologize.
Thank you, Mr. Chair. I have a lot of concerns with this. I mean, I'll be honest with you, I don't know a whole lot about fantasy football. Just like my cell phone, I don't know a whole lot about that either. But I did take a look at I share Representative Call's concerns about constitutional issues on this. I did look at our Constitution on the gambling sections of it. And you say this is not gambling, I'm sorry, but I have to disagree. I think anytime you're playing a game for money, it's gambling. And I did look up the definition for gambling, and it says gambling is when you play games of chance for money or you take risky actions in hope of a desired result. That's what I believe fantasy football is. And I don't condone anybody for playing it, I'm concerned because it is gambling. Gambling's an addiction. And there's so much.
I wouldn't say it is an addiction.
It can be an addiction to some people. Some people just don't know when to stop, and I think we're going to be sending some people on a quick ride into poverty. That's the honest truth about some of this. I'm sorry, that's the way I feel. As far as our Constitution goes, it clearly bans this type of gambling, and I think maybe if you had waited a little bit and done a little more research, you introduced this on the 25th. What's today's date? 27th. 2 days later, boom, we're having a hearing. We have bills that actually benefit the people of the state of Wisconsin, but yet we're spending our time on this, Mr. Chair.
Is there a question there, Representative?
Yeah, I know. I'll come up with one just to be rambling. Just kidding.
Well, I guess.
My question was,
Bright minds can disagree over whether or not the scope. I don't think that our Constitution is necessarily clearly defined. Back when this was addressed, there weren't things such as fantasy sports, fantasy games, things like that. And I think this is part of a process of bringing our statutes and bringing our laws to evolving societal norms, I guess.
okay, I'm gonna agree to disagree with you on this.
We do that all the time.
I know.
Representative Ripp.
Thank you, Mr. Chair. I think one of the things here is that there is a set fee going into this, and that's what the difference is between this and gambling. Whether you agree or disagree, but it is a set fee versus expanding into the pot or whatever. So, so there is a difference. So thank you.
Yeah, it is a set fee, but it's a set fee over and over and over again in hopes of that set fee is going to come back to you in hundreds of thousands of dollars. And what are the chances? Thank you.
Okay.
Any other questions for the author?
I'm happy to address any questions anybody comes up with offline too.
All right. Thank you very much, Representative.
Thank you, Mr. Chair.
Next, we'll move to Pete Shanky.
Yeah, correct.
Speaking in favor from Fantasy Sports and RotoWire. Thank you for coming. You have somebody else with you?
Yes, I call from another local company that does fancy.
Which one are you?
Sideline Software, we run myfantasyleague.com.
All right, great. You're Mike?
Yes.
All right, thank you for coming, gentlemen.
Good afternoon, Chairman Swearengin and members of the committee, thank you for the opportunity to testify today. My name is Peter Shanky, and I'm the chairman of the Fantasy Sports Trade Association. I know it's hard to believe that a trade association for the fantasy sports industry even exists, let alone that it has over 300 members, including ESPN, Yahoo, CBS Sports, NFL.com, and NBC. But it exists for a simple reason. Fantasy sports have become our new national pastime. Over 50 million Americans participate in some form of fantasy sports. Wisconsin is hardly an outlier. We estimate that just under 1 million residents participate in these contests every year. And they do so because it's a form of entertainment that gives them a deeper appreciation for the sports that they love. I have 3 objectives this morning. First, I want to make everyone aware that Wisconsin is a cornerstone of the fantasy sports industry. Second, I want to provide the committee with a brief primer on what a fantasy sports contest entails, with particular emphasis on the weekly or daily format. And lastly, I want to discuss why these contests, regardless of duration, are games of skill and therefore legal under Wisconsin law. In addition to being chairman of the industry's trade group, I'm also the founder and president of RotoWire, a leading information website for fantasy sports based here in Madison. RotoWire reaches millions of fantasy sports consumers through our website, rotowire.com, 2 print publications, and through top-selling mobile apps. RotoWire is also the leading provider of fantasy sports information to the fantasy sports industry, with customers such as ESPN, Yahoo, Fox Sports, NFL.com, FanDuel, DraftKings, and over 50 syndication partners. If you've played fantasy sports, it's nearly certain you've seen RotoWire's player news and injury information in your fantasy game. To power all that information, RotoWire has 22 full-time employees in Madison, along with 20 part-time employees and a staff of nearly 200 freelance writers across the country. We found Madison and the state of Wisconsin to be a great home for our operation, given the sports craze culture, the wealth of talent coming from the University of Wisconsin system, and the affordability of running a business. RotoWire is one of several prominent fantasy sports companies that make Wisconsin their home, including the most competitive season-long competition, the National Fantasy Football Championship, the leading customized fantasy football league management service, myfantasyleague.com, and home to several prominent writers and programmers to such companies as Fantasy Labs, the Fantasy Football Players Championship, and Advanced Sports Logic. If you're not familiar with these Wisconsin businesses, let me give you a brief primer on fantasy sports. I know that for some of you, this industry has come out of nowhere. In fact, some of you may be under the impression that fantasy sports did not even exist until the first week of September, when everyone started seeing all those ads. The truth is that fantasy sports have existed for over 35 years. And while there's been some innovations, the concept has remained the same throughout. The objective is to select a team of real-world athletes and participate against others based on a scoring system that turns on real-world statistics, as opposed to the outcome of a game. Let us use fantasy football as an example. We heard some before, but I'll give it again. Players typically draft or select a team of 8 real-world football players to fill positions like quarterback, running back, wide receiver, tight end, and kicker. Like any other owner or general manager, the goal is to assemble a team of players that will accumulate the most points. A running back, for instance, earns 1 point for every 10 rushing yards and 6 points for a touchdown. But again, I want to emphasize, fantasy sports is not about who wins or loses the game. It's about who performs the best in certain statistical categories. Take Aaron Rodgers, for example. He threw 4 touchdowns against the Panthers earlier this season, yet the Packers lost. Meanwhile, my team had Aaron Rodgers on the roster, and he led my fantasy team to a big victory over an old college friend in my league that's been around for 27 years. Now let us turn to the weekly or daily format. I think there's a view out there that these contests are drastically different from the traditional season-long format, that the latter is more akin to chess, while the weekly or daily format is akin to roulette or slots. Nothing could be further from the truth. The 2 formats are virtually identical. All of the same basic principles found in the season-long format exist in the daily or weekly format. You still need to assemble a team of 8 to 10 real-world players. You still have to fill multiple positions with players from different teams. And those players earn points through the exact same scoring system that we use in my season-long league. And the daily format resembles the salary cap contest provided in print publications back when I started playing. The only difference is the duration of the contest. Rather than wait till the end of a 17-week football season to crown a champion, a daily or weekly contest takes place over the course of a single day or weekend. Think speed chess versus traditional chess, or writing a story versus writing a novel. That brings me to my final point. Regardless of the length of the contest, fantasy is a game of skill, not a game of chance. It's not enough to know the most popular teams and their most recognizable stars. You need to understand scoring systems, the particular strengths of different players, the type of offensive scheme they play in, and the quality of their matchups. And I can tell you from my own experience, whether a participant wins or loses depends entirely on the amount of time, research, experience, and talent, otherwise known as skill, that he or she has relative to the other players in the contest. If you were in a fantasy league, over the years, you learn that some members of your league win more regularly than others because they try harder and have innate skills of picking the best players. In fact, the most common excuse that someone gives when I ask about whether they play fantasy sports is, I just don't have the time. You don't hear that about roulette or blackjack or other games of chance. And that's because unlike these contests, there's no systemic chance in fantasy sports. Winning and losing does not come down to the spin of the wheel, the roll of the dice, or the turn of the card. Or, in the words of one group, the typical fantasy sports league is not gambling because winning is based predominantly on skill and knowledge about the featured sports and its athletes, not on chance. In other words, fantasy sports leagues challenge the participants to exercise judgment-making skills similar to a coach or general manager. Now, those are not the words of some fantasy sports advocate. That statement comes from a 2012 guide that the group Stop Predatory Gambling prepared for state lawmakers. The $64,000 question for today's hearing is whether skill plays the same role in a daily or weekly contest. And the answer, at least in my mind and others' view, is yes. Skill is just as determinative of the outcome in a daily or weekly contest than it is in a season-long contest. It requires a different set of skills, but skill still predominates. Now, I know some of you are skeptical about this, but in a daily fantasy sports contest, you are forced to make a decision on every player scheduled to play that day. For example, in a traditional fantasy baseball league, few backup catchers are used because they play so infrequently. You need not study them. In a daily fantasy sports contest, suddenly every player is an option, even a backup catcher such as Drew Butera, who with a .507 career OPS ranks as one of the worst hitters in modern Major League history. If you choose a lineup with a bunch of superstars, you may be forced to pick a cheap player such as Butera if he's in the starting lineup. And he may be of value if he's playing at a hitter's park like Coors Field or faces a pitcher that he's had some success against. Yes, you need to study Drew Butera and hundreds of other players each night while also taking into account such factors as wind direction and platoon splits. It's a different skill set than used in traditional fantasy baseball, but I think you'd agree just as much work. This is also consistent with how Congress treated fantasy sports contests in the Unlawful Internet Gambling Enforcement Act of 2006. It exempted fantasy sports contests from the Act's definition of unlawful internet gambling. I know there's some controversy about this exemption, but no one can dispute its significance. Congress looked at this issue and determined that fantasy sports contests are not inherently games of chance, but can be structured to ensure that they are games of skill. And finally, it's consistent with the conclusion reached by Major League Baseball, the NBA, NHL, and MLS. All four of these leagues have kicked the tires on the legality of daily fantasy sports and kicked them hard. And all four have not only concluded that daily fantasy sports are a game of skill, they have partnered with and even invested in one of the two major daily fantasy sports operators. But we're not here today to tell the committee to leave fantasy sports alone. We are well aware of some of the concerns that have arisen in recent weeks. We came here today, just as we have in other states, looking for legislation that will provide clarity on the legality of fantasy sports contests and at the same time require operators to satisfy reasonable yet important consumer protection obligations. To that end, we welcome Assembly Bill 800. It's a tough bill for the industry and certainly not perfect. The $150,000 licensing fee will be very problematic for our members, but it sets up a framework that will allow us to continue to operate in the state while providing our players with a safe environment. We look forward to working with this committee and the legislature to improve this bill and to ensure that the nearly 1 million fantasy sports players in Wisconsin can continue to play the games they love. I'd love to take any questions. Representative Call, you had a couple questions that maybe I can just address right off the bat. States where it's legal. There's no state that's actually banned fantasy sports or daily fantasy sports. There are 5 states that have different definitions of gambling where if there's any chance, it's not considered legal. The companies in our industry don't offer games there. It's Washington, Iowa, Montana, Louisiana, Arizona. There's also Nevada, which recently ruled that it was gambling. We obviously disagree with that, but you have to get a gaming license in order to participate there. We think that's a very heavy burden, very expensive, very tough for our operators. That's not a path that we'd like to see for our businesses. And then you asked about how this might impact the Constitution. We don't view this as gambling. It's not a gambling product. It's a game of skill. It's no different than a golf tournament or a bowling tournament where someone might enter a fee to play and they might win a prize on the way back. So we feel like that definition, as it is in the Wisconsin state law, it defines fantasy sports not as gambling. So therefore, it shouldn't have those problems. But we want the clarity here, given everything that's going on in the industry and around the states. And we've been visiting states around the country to try to work with legislatures to come up with, like I said, a clear definition and also address some consumer protection issues. Thank you, and happy to answer any more questions.
Mike, you want to weigh in first, or?
Yeah, go ahead.
Sure, I'd be happy to. Thanks, Chairman Swearengin and the members of the committee. Thank you for the opportunity to testify today. My name is Mike Hall, and I'm the president of Sideline Software, Inc. My company is based in Fitchburg and was formed in the early 1990s to help fantasy sports players run their private fantasy football leagues. Our premier product is an online fantasy football league management system called MyFantasyLeague.com. We host over 25,000 fantasy football leagues, and our software is used by over 250,000 people, and our website generated over 1 billion page views last year. Wisconsin has a long, proud history of being a leader in the fantasy sports hobby. While fantasy sports have been in the news lately, this isn't an industry that just developed overnight. The first fantasy sports magazine began in Wisconsin by Krause Publications in the small town of Iola in 1989. The state has also been the home to pioneering companies offering salary cap games, league management services, player news, and other information. And today it's fostered a community of leading information, league management, and contest sites that call the state home. My own company is a pioneer in the fantasy sports industry. We debuted our league management product in 1994, well before companies like Yahoo, ESPN, and NFL.com started offering their products. Sideline Software helps the Wisconsin economy by contracting with other local Wisconsin businesses. We host all of our servers at CDW Burby, which is a Fitchburg-based ISP. We use a local accounting firm based out of Middleton, and we have a cross-promotional partnership with other companies based out of Wisconsin that are in the fantasy sports industry. Fantasy sports have grown rapidly in popularity the past 20 years, fueled by technology and innovation that doesn't often fit with centuries-old laws. Daily fantasy sports in particular have boomed the last few years, along with the growth of mobile devices. That growth has brought our industry new challenges. Wisconsin needs to work together with our industry to grow this business, which we already know is good for the pro teams, the pro leagues, the TV networks, and even the athletes. More people watch pro sports because of fantasy sports, and now even more because of daily fantasy sports. I'd ask that you be mindful of the many small businesses, such as my own, that have been operating in the state for years as you consider the new regulations. In particular, I am worried about the large registration fees in this proposed bill could limit the growth of my business and possibly result in only a few companies being able to operate in the state. We need a regulatory framework that gives all fantasy sports players an even playing field while not being so burdensome to deter small businesses and new startups. So I look forward to working with this committee and the legislature to ensure that fantasy sports continue to thrive in Wisconsin. Thank you.
Representative Branchen.
Thank you, Mr. Chairman. I love football. I love these games, and I think that with technology, it certainly makes the rates and getting the stats so much more easier. But you're going to have a hard time convincing me that when Gronk's knee blows out, that there's not luck involved in the game, or when Rodgers gets hit hard enough, that there's luck into the game. So how would you address that?
So we would say there's definitely more skill than luck. There is some luck involved, right? But the difference between this and a gambling product like blackjack or craps is no luck has to happen. There's no card that gets turned over. Going into the week, you could pick all your players.
So if Rodgers gets hit and he's on
doesn't have to happen though. I mean, if we pick all the players and it goes like we think, no one gets hurt. There's really not a lot of injuries.
That's not football. I mean, that's the difference between the Packers being in the playoff or not. It could be injuries.
But there doesn't need to be a luck event for this game to happen and for you to be able to succeed. And that's the difference between that and gambling. And what over the years, whether you play the leagues that I played in full season or short season or daily, after a while, the people that are better, they win more often. And that's a sign of a skilled game, whether it's golf or bowling or anything else. Some people who are better, who try harder, who have better skills, they succeed more often than not. That's not the case in blackjack or roulette, where nobody's any better than anybody else. Maybe the slightest fraction if someone doesn't know what they're doing, but no one is really that much better than not. But golf and we think daily fantasy, there's people who are better than others because they try harder and they research.
Well, I thank you for your. I wish your companies good luck, and I appreciate what you do, but I think there's still maybe more luck here than you're willing to admit. But you admitted part of it.
Again, there is definitely luck involved.
Oh, okay.
Again, we want to work with you to ensure that this business can continue in the state.
Thank you.
Representative Call.
Thank you, Mr. Chair. I want to be clear that I'm opposed to what you guys do.
Yeah.
I support it. Thank you for doing it in Fitchburg. But you just said twice, there's luck involved. You just said 5 states don't allow it because they've determined there's a chance of luck. That's where my concern is, because you can pass this law, but it still conflicts with our Constitution, and when that happens, the Constitution wins. And then you put at risk, maybe Ledge Council knows off the top of their head, but it's pretty significant revenues we have under the compacts with the various tribes in this state. So if you really want to do this, I think you've got to amend the Constitution. Because I just don't think we can do this, because you've just twice on Wisconsin I said it involves luck. And you told us 5 states said you can't do this because it involves luck. I'm not willing to put at risk those compacts, because somebody will challenge it. And then we're going to have a big problem. So I want to figure out how we can make this work. I just don't know that this is the vehicle to do it. Because I do support what you guys are doing. I respect it. I have no problem with people playing fantasy sports at all. I'm in fantasy football leagues myself, those type of things. March Madness is coming up. But this is going to create a potential problem for us. That, as I jokingly said earlier, and, if you guys are willing to indemnify us, but you'll want to know what that amount is, because $150,000 ain't much compared to what we're going to lose under our compacts if they're challenged, which I suspect they will be.
I mean, I understand your concern, but the definition of gambling in Wisconsin is if there's more skill than luck, it's not considered gambling. We think ours is a skill game, and so we feel like your concerns, while I understand, shouldn't be there. We've seen that in some other states. 2 states have actually, there's no state that's banned fantasy sports. There's actually 2 states that have passed similar laws to this to fully legalize fantasy sports, both in Maryland and in Kansas. And in both of those states, they didn't have the issues that you're worried about. Those didn't pop up. Also, it was not a backdoor or a gateway for the expansion of gambling or online gambling. It wasn't the loophole for some other formats. And so I think that those concerns, as we've seen play out across the country, haven't happened so far. And again, we're a game of skill, I think, so I think that should alleviate those.
If I could, then, you mentioned Maryland and Kansas. If Ledge Council could look into those and see if they have similar constitutional language that we have. Thank you.
Representative Ritt.
Thank you, Mr. Chair. Question on, I guess, number of employees and ballpark as far as, let's just go with the employees, I guess.
So Rotowire.com has 27 employees, 22 of them are here in Madison. We've grown from 6 employees 10 years ago. We also have a lot of part-timers and freelancers and a great relationship with the University of Wisconsin for some interns and part-time hires. Mike, you want to say how many employees you got here?
Sideline Software has 5 employees.
And there's a couple other businesses in the state that have employees, single digits, around there. So while we're not a big presence in terms of the number of employees, we are a big presence in terms of the footprint we have in terms of touching Wisconsin consumers. Over 1 million players here, some visible companies. I think it's great for the state.
Okay, thank you.
Any other questions for the gentleman? Representative Rostock.
I just thank you, and thank you for coming down. I just wanted to ask, if you can elaborate a little bit more on the 50+% skills versus 50+% luck aspect of what we're talking about today. And I know you said, I think a little bit off the cuff, there is luck involved, but I think it's also arguably, you could say, in almost any game where there's not complete and total knowledge of all the information of chess, there's going to be luck.
Yeah. In any game of skill, there's a little bit of luck. In fact, chess, which we'd all would say is the ultimate game of skill, right? There's no luck, but you still have to determine who goes first. And so that coin flip, or however you do it, invites some luck into the game. In fact, there's a 4% advantage for the person who goes first in chess. And you see it in golf. How many times have you seen in golf, guy's going to make a birdie, it's a great shot, hits the flagpole, goes into the trap, right? So there's always a luck element in any game of skill. And so we are not saying that we are 100% skilled. There's a small amount of luck. But we think it's beyond 50%. In fact, we think it's beyond 75, 80%, beyond a material element, which is a case in other states. And we have a number of studies, which I'd be happy to give to the committee. We've done some research that show that the skill is 80, 85, 90% in that threshold.
Yeah, and to that point, full disclosure, I don't play fantasy sports, but I'm a huge gamer, and I love games, and I was on the professional tour for Magic the Gathering many years ago, so I love games. There's no bigger gamer than me. And as someone who, not in this building anyway, as someone who, a little trivia for you, yeah, as someone who games a lot, and it's activities my wife and I enjoy a lot. You know, we have other couples over, and it's something I still am very competitive with. I think a lot of people, there's some subtle distinctions that are important between what's more skill-based, what's more luck-based, and I think that although you'll provide us with statistics, if you know, I think it's most appropriate to go through the chairman on that of the committee, but I'd love to see those. I think it's also important just to give a little bit of an idea of what that looks like, and if you could just give some examples of why someone who, for example, puts the time and effort to research the place, research all the other statistics involved, research fields people are playing on, and other, you know, other factors that can play into the results would do better than someone who has not put in that amount of time in research. Would be helpful.
Yeah, if you try to play one of these games, and I would, you know, I'd welcome anyone to try, you know, go play one of our member companies. You will quickly notice how much work it is. You know, even to figure out who's going to play that day, who's in the lineup, who's going to be any good, and you will eventually you will not do well initially, and then eventually as you learn more skills, you'll get better. And even for someone like myself who's been doing this for years, if I'm going to play a daily fantasy sports game, it takes me an hour to research to be competitive, and if you know, just like the leagues that you've been in with your friends over the years for daily fantasy sports, the people who put in more work and time and research and have their own programs and you know come up with their own formulas and statistics, they're the ones that do better, and that's we've seen that play out over and over again.
Yeah, and yeah, I just I appreciate that, and I appreciate the information that you're going to share with us to kind of prove that out. But yeah, just want to kind of make that distinction and say that there is, you know, a lot of work that goes into being successful at these games. I've seen other studies to show it, although we don't have any of that information in front of us, versus people who don't put that time and effort into, and the same with any other, you know, with any other game of skill. So appreciate it, and thank you very much for your testimony.
Thanks.
Any other questions for Mike or Peter? Seeing none, gentlemen, thank you very much for taking the time.
Thank you so much. Thank you.
Next, we have Jelaine Appling from Wisconsin Family Action, speaking against. Good afternoon, how are you?
Good afternoon, I'm doing fine, thank you. Well, thank you for this opportunity, Chairman Swearingen and committee members. I have some prepared remarks that are being passed around right now, but I want to just make a couple preliminary comments after hearing Representative Warpagels and the other gentleman's testimony. I think, first of all, we have to acknowledge this is an extremely contentious issue, not just in Wisconsin, but all over the country. This bill was introduced on Monday, and we're having a hearing today. I believe that the timing on this is not in the best interest of Wisconsin. And I will reiterate this, but I believe that an appropriate action would be to ask Attorney General Brad Schimmel to issue an opinion on this matter, because we have some questions that have already been asked today about the constitutionality of it. How does it bump into that? What does it do with other statutes related to gambling? I also want to clarify, we're kind of using interchangeably the term fantasy sports and daily fantasy sports, and they are not the same thing. They're very different, and that's part of the reason that you have the contention, shall I say, and the disagreements across the country. I believe that, let me just say, first of all, our organization is deeply interested in the welfare of Wisconsin's best natural resource, which is our families. And as such, we expose the expansion of gambling in any form in our state, and we have been extremely consistent about this throughout our organization's history. We believe, however well-intentioned the authors of this bill may be, that AB 800 will result in an unprecedented expansion of gambling, and therefore we do oppose it. I became aware of daily fantasy sports because, as an ardent Packers fan, I regularly check the team's website. And during this past season, between being incredibly elated and hopelessly in despair, I frequently saw attention-getting banner advertisements from FanDuel. Curiosity finally went out, and one day I clicked on the ad. And when I landed on the page there, my immediate reaction was, wow, this is online gambling. I thought that was illegal in Wisconsin. That was my immediate response to it. I do not gamble. I don't know the lingo, and it's probably going to become terribly apparent, but I don't. But I do understand the concept. It looked like gambling, it sounded like gambling, it felt like gambling. I bailed out of the site, and I didn't think much more about it until I began reading news reports from all over the country indicating considerable controversy in a number of states over daily fantasy sports, and whether or not, and this is the nexus of the argument, is it gambling? And would it then be therefore illegal in most states, including Wisconsin? AB 800 seeks to make a distinction that games of skill should not be considered gambling, and even asserts that DFS is not gambling. We disagree. DFS is not like fantasy sports, an activity that spans an entire season and is not about cash investments or cash winnings. DFS contains all the elements of gambling, including a player making a wage, cash prizes, and chance. Skill is not only not required, but actually having unskilled players as well as skilled players in the game is absolutely necessary for the game to go on. A good analogy might be poker. Poker, when it's played well, takes quite a bit of skill, and everyone recognizes poker is gambling. No one would contend that it's not gambling because it's a game of skill. They wouldn't make that argument. Online poker is illegal in Wisconsin. I double-checked that just last night, since I didn't have much notice on this hearing. Daily fantasy sports should be as well. I would also say, I don't understand why no one's made this argument. So understand that, because I don't gamble, I don't know all those details. But I do know horses, all right? And I know people who bet on the ponies. And what do they have to do? They have to have an incredible amount of skill to be able to be successful in their gambling. They have to have an understanding of a horse anatomy, because they have to be able to look at a horse and gauge whether or not a horse is good for a certain distance that they're going to be running in that particular race. They have to have an understanding of course conditions of the other horses that are in the race. No one would say betting on the horses is not gambling. No one would say that. I believe, as Representative Sinicki and Representative Branchin have said, I believe that you are dealing with more than 50% luck on these games. Regulating DFS as proposed in this bill simply legalizes this online gambling. I do believe that it would then, quite honestly, if I were one of the tribes running casinos, the very next thing I would ask for is, I want in too. And I don't know on what grounds you stop them. I think they would build a case, if not before the legislature, at least in the courts, that what has been legalized through daily fantasy sports is gambling. And so I think we're opening a window. We're also ensuring through this that only a select few will be able to afford to launch DFS enterprises in Wisconsin. As the gentleman just before me admitted, the $150,000 entry fee for the businesses will be prohibitive to many, thereby creating something of a monopoly in this area. And I got to assume that our state legislature is not really amenable to doing that. In recent months, a number of experts, as well as state attorneys general, have opined that DFS is indeed gambling. Late last month, Illinois Attorney General Lisa Madigan deemed that under state laws, DFS is gambling in Illinois. She noted, and I quote, "Participants in the online fantasy leagues must pay an entry fee or buy-in amount in order to win a prize. Consequently, the act of playing daily fantasy sports contests in Illinois constitutes illegal gambling." Recently, New York Attorney General Eric Schneiderman determined this past November that DFS violates New York's gambling laws and asked courts to stop FanDuel and DraftKings from operating in that state. Schneiderman wrote in an op-ed that was published in a New York paper, and I'm quoting him, "Daily fantasy sports is much closer to online poker than it is to traditional fantasy sports. Unlike most traditional season-long fantasy sports rights, which make most of their money from administrative fees and advertising, FanDuel and DraftKings take a cut of every bet. This is what bookies do, and it's illegal in New York. He goes on to say, in fact, as our court papers lay out, these companies are based on business models that are identical to other forms of gambling. FanDuel was created by a veteran of the legal online betting industry in the United Kingdom, while the CEO of DraftKings suggested that it operates in the gambling space and described its revenue model as identical to a casino. That's from the people who have been in the center of the industry. Earlier this month, January, Vermont and Texas have stated DFS is gambling and violates their state laws. You can add Nevada to that list as well. No doubt there will be others as the reach of DFS expands. Obviously, this is a contentious issue, and states are beginning to line up on many of them on the side that says DFS is gambling and is therefore not permitted per state law. Simply declaring, as AB 800 does, that DFS is not gambling does not make that truth or reality. Pardon my simple analogy, but I can declare that a dog is a cat, and that doesn't change the truth or reality even if I dress the dog up like a cat. It's still a dog. You can call it whatever you want. I realize that there's a great deal at stake monetarily, financially in this. Some estimates are that by 2020, we will be talking tens of billions of dollars in this industry alone. Tens of billions of dollars. And I also realize the federal government has deemed this game legal from the federal level, but it has also very wisely said that the states' laws will trump federal law on this. And I would certainly say that just because the federal government says something is good or right doesn't make it either good or right. It certainly doesn't make it good or right for our state. We oppose AB 800 because we believe this online gambling will be a siren song that many Wisconsin residents, in particular young people and especially young men, even teens, will not be able to resist. We know gambling can be addictive. We know that, especially in an online setting, that can be true. When gambling is as near as a smartphone or a tablet or a desktop computer, we are a state just asking for problems. Wisconsin Council on Problem Gambling has reported that as of 2014, calls to the council's 24-hour helpline have increased, this is staggering, 329%. 329%. And that about 330,000 Wisconsin residents are classified as having a gambling problem. Imagine, folks, the magnitude of the problem if we go down this road of legalizing online gambling, which would be basically available anywhere, anytime. Stories are just now beginning to surface, because this is really very new, of people, especially young men, who have become addicted to DFS gambling. Joshua Adams from New York is one of those. He's a problem gambler who thought he had his problem under control until he got involved with DFS. In his words, absolutely it is gambling. To him, and I'm quoting, games with a single payout after the season didn't seem to him like gambling. That's the typical fantasy sports. It was very different, though, he says, when the action became daily, offering quick payouts, hundreds of bets each day, and six-figure cash prizes. 30-something Adams says DFS was a game changer. Those reports are just beginning to surface. We know that this is just going to open the door for more of those problems in Wisconsin. Rather than trying to legalize, regulate, and embrace this business, Wisconsin ought to join the other states in declaring this newest expansion of gambling illegal, according to Wisconsin law. At a minimum, and I reiterate this, we should seek a statement from our Attorney General on this matter and not rush this bill through. Too much is at stake. As always, I believe gambling is a bad bet for Wisconsin because it harms our state's best natural resource, our families. I urge you, please slow down on this bill and consider it carefully, because the information I and others will present today needs to be heard. In the end, I hope you will come to the responsible decision and position of standing down on this bill. Thank you for the opportunity to testify. If you have questions, happy to do my best.
Well, thank you very much for taking time to address the committee today. Any questions for Ms. Appling? Yes. Thank you, Mr. Chairman, and it's certainly possible, since I was, had to miss a lot of the testimony today, that this could have been covered, but one question, when you mentioned the Native American compacts, I'm just wondering, I guess this is probably a question for Ledge Council, how would this square with the agreement that the state has with Native Americans regarding gambling?
I'd have to look at the precise language in the contracts, but there is an exclusivity clause in the contracts that if other forms of gambling are permitted within the state, then the payments under the gambling compacts would stop.
So, if I may, just to follow up, since what this essentially would be doing is saying that this isn't gambling, you know, I guess all it would take would be some tribe, be it the Potawatomi or Ho-Chunk, go to court and say whether or not this is a dog or a cat. And there's little doubt in my mind that the court would determine that it was a dog. I just wonder what the penalty would be in terms of violation of the compact. And perhaps if you could give the chairman that information.
So just bring up to speed, Representative McCall, the same concerns earlier on in this discussion. So.
Okay, thank you. Any other questions for?
Craig?
Yeah.
Oh, you can take Representative Craig first.
Just for Ledge Council, so, you know, in my neck of the woods, Representative Onsted's sort of neck of the woods, we had, you know, some prominent dog tracks where betting was allowed. Was that just an exclusion from the compacts and in congruence with the Constitution?
There's a specific exception under the Constitution for parimutuel on-track betting.
On track, okay. Thank you.
Representative Sinicki?
Thank you. Mine's not really a question, more of a comment. I would like to declare today a state holiday because I think for the first time in history, Ms. Appling and I are going to agree on something.
I
Bringing
couldn't
people
imagine
together
that you
are-
or Representative Zammer-Ripa would miss the opportunity for some elucidating comment like that. Thank you,
Does that mean
Representative.
we get the rest of the day off?
Yeah.
Any other questions for Ms. Appling? Seeing none, thank you very much for
Thank
your
you.
time. And lastly, of Lori Pickens with Citizens Against Expanded Gambling.
Thank you, Chairman Flanagan, and thank you, committee members, for the opportunity to speak before you today. My name is Lori Pickens, and I'm here representing an organization named Citizens Against Expanded Gambling. We basically a coalition of concerned citizens, employers, and community members across the state who oppose any expansion of gambling in the state of Wisconsin. And accordingly, AB 800 presents a very great concern for us. This bill represents potentially the largest expansion of gambling in Wisconsin history. By defining daily fantasy sports as a game of skill, you are literally opening up a casino and a lottery retailer in every bedroom and smartphone in the state of Wisconsin. The daily fantasy sports games themselves are dishonest and predatory. Legalizing them doesn't change the reality, it's really a public ripoff. Moreover, daily fantasy sports meets the requirements of the fundamental definition of commercial gambling and have a fundamentally different relationship to those to chance than long season fantasy games do. You're not talking about an expansion of over a season. Daily and weekly bets really change the entire dynamic of the skill versus chance. On any given day, an injury, a snowstorm, or a ball bouncing strangely could affect that result. In this regard, placing a wager with a daily sports operator is very similar to placing a bet with a bookmaker. It has consideration, the player wagers money, it has the prize, the player wins cash prizes, and it has chance. There must be at least enough variance that the unskilled or lesser skilled bettor can win the prize, at least in the short run. Calling it a game of skill doesn't change that reality. It becomes a public deception. Many of America's casinos operators and gambling regulators publicly call the daily fantasy sports gambling. MGM Casinos chairman Jim Murin recently said that those who argue that daily fantasy games are not gambling are absolutely and utterly wrong. He added, "I don't know how to run a football team, but I know how to run a casino, and this is gambling." Even the people who run these daily fantasy sports sites publicly admit they are running a gambling operation like a casino. DraftKings CEO Jason Robbins acknowledged on his website was almost identical to casino in an online discussion on Reddit 3 years ago. AB 800 is going to legalize fantasy sports gambling and provides the entryway for all online gambling in Wisconsin. Gambling has grown at a very extraordinary rate here in Wisconsin since 1989 when they legalized the lottery. This growth has come with very serious consequences. Wisconsin's own Council on Problem Gambling shows an alarming increase in problem gambling with direct correlation to the expansion of gambling in Wisconsin since. As Jelaine pointed out, approximately 333,000 Wisconsin citizens currently have a gambling problem. Calls to the problem hotline have increased 329%, and the average debt of these callers is $46,967. Rose Gruber, the executive director of Wisconsin Council on Problem Gambling, said in a recent interview that the total numbers of those calls really only tell a very small part of that story. The calls in 2015 included a call from a woman in Sauk County who said her boyfriend attempted suicide when she found out he had a gambling problem, a call from an Allegheny County man who said he was now homeless due to gambling, a Brown County caller who says he gambled away his $500,000 inheritance from his father and maxed out his credit cards and lost his job. If we legalize online gambling, all you really need in the state of Wisconsin is a credit card and a computer, and you're one click away from losing it all. I understand that there are concerns of the financial ramification of what our Constitution says, and I mean, it really clearly is gambling. I mean, I don't really know how you get around that. And I'd also like to point out that in earlier testimony, a couple people referred to the Unlawful Internet Gambling Enforcement Act. It was authored by Representative Jim Leach, who recently told reporters that allowing the DFS was never their intention. That quote, the assumption was that while unconstrained internet gambling could change the nature of America's savings and investment patterns, fantasy sports would be a de minimis footnote. No one ever conceived of it becoming a large-scale activity or that it could transition into one-day contests. So that with heavy heart, I think we have to really look long and hard at this and look at the total impact and what it does to the state and to its citizens. And I strongly urge you to oppose this bill and take a deeper look at it.
Leave your testimony. Any questions for the witness? Seeing none, thank you. That is it for speakers. Registering in favor, Senator Roger Roth, and registering in favor, Ryan Murray, representing DraftKings and FanDuel. With that, the committee is closed. Are there any announcements from the clerk?
Rob mentioned that we could be meeting up to 2 times a week moving forward as early as next week.
Okay, thank you.